1392, 1727, 894,
My lord, 663.
1091,
663.
846 and 569 are identical matters.
846,
And 569.
569. Yes, madam.
1209, 1210, and 1.
No, not so many. 1209.
1210 and 1211.
What is happening? Just see what is happening.
1210 and 1211.
1210, 1209, and
1211.
1211. 1256. 1451.
Lordship, item 1507.
Somebody is there in front of you. Please do not do this. Please do not do this.
836.
Are you wearing your gown? I cannot see. It's gone down.
836, your lordship.
836. Yes, go out. 1329.
1507.
1507. 1006.
My lord, 454. My lord, 454, 455. Then my lord, 780.
So many. 454,
my lord,
455. 1490. 1491. Somebody is there in front of you. 777. 927.
My lord.
Yeah.
My,
1286.
my lord, may I?
Yes. 15660. 1704. Move out.
My lord, the item number 1579.
You mentioned just now one matter. One at a time. Is a rationing going on?
My lord, the item number 1579.
1524? 1124.
Rationing আছে এখানে
1342. 1345.
My lord, may I be allowed to mention one?
1539. All similar matters. Yes, madam.
My lord.
1 minute.
1 minute.
1255.
My lord.
1107.
My lord, the item number 1579.
1579.
My lord, 663.
663.
My lord, 657.
657.
481. 711.
711.
1481.
1681.
1481. 1481.
1481. Yes, madam.
Madam, 594.
594. Move out.
1497. 1497.
1497. Out. 1243. 1485.
My lord. Yes.
1236.
Lordship,
1486.
Lordship, 538. Lordship. She's even not even looking at you.
Yes. 12. 1626.
Item number 316. 526.
921.
316.
538.
My lord. My lord, 1533.
No, not in this manner.
526.
526.
And 1130 and 1131 both are identical matters. 1130 and 1131.
Lordship. 1130, 1131.
Lordship, 230, Lordship.
My lord, item number 316.
316. Move out. Move out.
Lordship. Letter 732.
1131. 33.
My lord, 1168.
Not from behind. Yes.
Lordship 732 and this
732.
598.
Why 2? 598. Yes, madam.
17.
17?
217.
217.
My lord,
236.
230. 230.
230. Move out, move out. Please let the woman
lord.
get out.
Hand over the slip, right?
No, you don't have to. 636.
my lord, 1533.
Go out, only one. Out. Please go out. 655. 1133. 834. 1086. 1319. Yes. 1662. 169. 169 and 170. 569. 1.
My lord,
Wait.
my lord,
259.
my
496. Out,
my lord,
please.
1354 and 1404.
1354.
1354 and 1404.
1354.
1404. My lord, 1168 and 1332.
My lord, my lord, 1533.
1332. 961. Out.
486. My lord,
1075. 13.
my lord, 1533.
1725. 1790. One at a time. I've taken 2.
486.
1125.
My lord, 1533. My lord, 1533.
74.
1533.
1533.
1534. 1534.
Please out. Those who have finished, please go out. Please go up. 485. 1094.
My lord, 874.
I will not accept your mentioning if you continue in this manner. The court is looking at that side. You are shouting from that side. What is this? It's not a free for all type of thing. Please wait. Yes. Again, I am telling somebody and you are from behind. You are a senior member. He's a junior. Yes.
1349.
426. Yes, please let the ladies go out.
1349.
1349. Yes.
1787.
1787. 1089. Please maintain decorum and let the ladies go out. 1827. 07. 1296. 1428. 639.
My lord, 400.
1069.
My lord, 4.
Move out. Let the ladies, let the women move out, please. 1769.
My lord, 105.
Yes, madam.
1197, 1202.
No. 1197. One. Only one. Please let madam go out. Let her go out, please.
My lord,
My lord,
Yes.
486.
486.
874.
Yes.
74.
Only one, please.
My lord, 74.
874.
874.
All right, go.
My lord, 386.
Yes. 1765. 771. Are they analogous? All right, move out. Slips not required. 1323. 1666, please.
ঘুরে আবার এদিকে আসবে
Oh, 1706. Hand over the slip. Yes, madam. 601. One at a time. 1421. Slips not required. 1400. 1164. 1402. Yes, madam, you're standing. Final hearing, please do not hand up.
My lord, 5 similar
It's
matter, my
not
lord.
possible. Yes. I can understand there are so many matters, it cannot be done. And prior to the vacation, it's absolutely impossible.
My lord.
Yes, madam. 1494. 1303. 04, all right. 1289. 1150. 552. Give handover slip. 1296. 1. 1408.
My lord, 1096.
1096.
1242, my lord.
1242.
My lord, 427.
427.
My lord, 400, 406, all similar matter, my lord.
400.
3, 404, 405, 406. And one is out of the list, my lord.
403 to 406.
1271.
My lord, one is out of the list, my lord.
Out of list.
1271. 970.
My lord, I have one leave, I would pray, my lord.
1271.
1053, my lord.
1271.
947.
947. 1314.
751, my lord.
6415. Just now you mentioned one? No? What?
1053.
1053. I cannot hear you, sir. Yes? 13? Huh? 22. 1322. How much? 978.
889,
88.
889.
All right. 1070.
1761.
1029. Your band is not proper. Wear it nicely. Yes.
761, my lord.
17. All right. Yes, sir. 1287.
Lordship.
1062, my lord.
1062.
1462.
1462.
751, my lord. 7.
184.
1493. My lord, 751.
No one.
1493.
1493. 711. 1369. আপনি কে ইন পার্সন মামলা করছেন? আপনার কোনো উকিল বাবু নেই কেন? Let her go. Yes, madam. 718.
751.
1530. 3.
My lord, 751, my lord. 751. Lordship for
751.
715.
715.
958, my lord. 958, my lord.
I am rationing it. Cannot
Lordship
help.
for restoration, lordship.
1206. Yes. Mr. Sengupta,
Lordship, 996.
Observation which has been filed is a very urgent matter. Surfacey and madam, it is law. Lord says that if it is a tenanted property and that too,
what you want? I'm not listening to anything.
any 13-4 symbolic question was already been the initiative.
What you want? Inclusion.
Madam, this is not the listed one. Madam,
You want inclusion. Want to move? Move means the file, has it been filed?
my lord, the last-
Has it been filed?
Yes,
There is a number.
number, and I have served them notice.
Is it appearing in the list?
No, it is not appearing because my lord, because I want to actually, I intended to take a leave from my lord. Just because that
When was the number given?
my lord, 173
When was the number given?
Friday.
Friday. That is the reason it has not been listed. Give.
My lord, so that my lord, it can be heard. That I am
It will be a urgent motion serve notice Wednesday.
already served. Oh, yes, again I am served.
Wednesday it will appear. এটা দিয়ে দেবেন urgent motion হিসেবে.
1450.
1450. Just now you mentioned one. Please do not. I am rationing it and you all are taking advantage of the whole thing. Yes. 1452.
My lord, 1657.
1657. 1298. Yes. 806. Yes. 1350. আপনি দাঁড়িয়ে আছেন কেন?
I want to mention one case, 8750. It was 4 months.
4 months before, is anybody appearing for you? In person? Why?
That should be 215.
215. All right. Go. Slip is not required. Go. 1036. Serve notice upon the other side and follow the list. Yes, sir. 1295. 1031. 161. 161. Yes. 1724. 1724. No further.
I'm praying for leave, my lord. Now, my lord, I'm praying for leave. My lord, the primary council, the council for my lord, in respect of my lord, pharmaceutical technologies, my lord, this is constituted for 5 years. My lord, my client was, my lord, nominated for 5 years in 2021. Now, my lord, before expiry of his term, my lord, now, my lord, this impugned memo has come, my lord, which says that there will be another person and the entire council has been reconstituted, my lord.
Yes.
My lord, this is
It has been reconstituted. What
has
can
been
be done?
reconstituted. That is the challenge before a lordship.
Then it will
Even-
file it in the department.
Now, my lord, what the urgency
may I-
is that, my lord, they after the reconstitution, they have to elect the members amongst themselves. That exercise has not been done. If they do so, then, my lord, their rights will be created. I'll be praying, my lord, so that I can move before that exercise is done. That is a statutory exercise has to be done.
Thursday, serve.
My lord, may I have, my lord, may,
It cannot be done by Wednesday.
Present a writ application, my lord, it is, my lord, the sale notice has been
My lord.
issued on each property and date has been fixed on 7th of this month, my lord, 7th.
Yes.
But what happened, this is checkered.
my lord, may I,
But I myself and my wife constitute a private limited company. My lord, your lordship kindly-
My lord, may I have,
It has not been affirmed.
No, my lord, the department is not allowing me to affirm because, my lord, my wife, my lord, relinquished his right in favor of two other person and he divorced me. And the other two person who introduced are two directors are not.
Listen, as regards the affirmation, you have to see what is to be done. I can only direct you. First you affirm, then only you can come and get the
Unless
leave.
your lordship grant leave, they are not because, my lord, what happened? My lord,
Grant leave is only for moving it on urgent basis, not for affirmation.
my lord, unless your lordship direct, my
My-
lord,
No, I cannot
But
direct.
you-
I do not know what exactly.
My lord.
Person now, but initially we were two. My wife divorced me and introduced another two persons. They are majority. They are not taking resolution for moving this application. And property which has been mortgaged is my property. I am the third director. But unless your lordship grant, they are not allowing me to
No,
afford.
it's difficult.
My lord,
I do not know whether you at all have any right to move it. Then how can we get it affirmed minimum? See,
properties of mine.
I understand, but then affirmation, the authority is not going to see.
One of the department concern has one of
Worked
the.
out a regulation.
Why will the department? I do not know. Who have you made? You are the writ petitioner.
I am the
Then why will the authority?
director. And my lord, but the
There is no authorization of the other members. So one of the directors cannot be helped.
two
Sorry, it
person was
cannot be
there.
done.
My lord, your lordship.
No, sir, I cannot figure it out.
My lord, may I,
Allow.
No, I am sorry. Yes.
my lord, may I,
Yes.
Mentioning this matter, second round of litigation. Well, gross medical negligence,
na takala mi kuro.
part of forgery also, well, taking LTI. But what I pray with your lordship for an independent and impartial inquiry by any other medical.
But for this, you want a leave.
But it kindly takes it up because this involves the question, well, a person, well, they have been this question of medical, gross medical.
All right. For that, leave is not required. You can file it in the department. I am accepting urgent mentionings. Please file it in the department. No, yes.
My lord, may I have your lordship's leave?
This is pertaining to DG arrest of a person without retired without retirement benefits and fixed payments.
Yes.
That has been mentioned to me, listed on.
No, no. If it has been mentioned, then please do not.
My lord,
Yes.
may I have?
1401 and 1.
I have finished all those applications.
My
No
lord, may
further.
I?
Lordship.
My lord, may I have?
Only
My lord, may I have? My lord, may I have?
My lord, 6.
My lord, may I have your lordship's?
The list. Please
Lordship,
let
kindly allow me, Lordship.
Sir,
Lordship, kindly
let's
allow
come
me
up
to
with
mention
others.
one
I am for the
matter.
private
My lord,
opposite
may I have
party,
your
my lord.
lordship's kind
I
leave?
am protected by an order, residence order, my lord. Challenging that order, the my lord, petitioner filed this writ petition, and now they showing the pendency of this writ petition. My lord, they are not allowing the district protection officer, my lord, to execute the order. My lord, kindly take up this matter, my lord. I am in, my lord. I have to stay otherwise, my lord.
See, otherwise
My
means?
lord, elsewhere, sorry, my lord.
Yes.
For that reason, my lord, kindly take up this matter, my lord.
Take up. I have taken up so many urgent mentionings. Then you didn't upgrade.
No, my lord, I was there, my lord. I was little bit.
Sorry.
My lord, kindly.
Lordship,
My lord,
kindly
may I have-
allow me to mention one
My lord,
matter.
I am.
The list upon service to the opposite party.
Original side. What stage is it in?
It is, the affidavits has been completed, it is for hearing.
A hearing prior to the vacation, please do not mention.
My lord, may I have your lordship's kind leave?
What do you want?
Kindly allow me to mention one matter, Lordship.
No, sorry. Nothing doing now.
My lord, I.
No further updates. Extension, hand it over.
My lord, may I
Lordship,
have your
kindly.
lordship?
My lord, only this.
Give.
My lord, may I have your lordship's
Lordship,
leave, my
kindly
lord?
allow me to
Correction.
mention
My
one
lord, only
matter,
this
Lordship.
matter, my lord.
Correction. Give.
My lord, for withdrawing on application, my lord, item number 1577 of the monthly list, my lord.
For
withdrawing as non-prosecution, my lord.
withdraw.
Instruction, my lord.
Yes, give. Don't hand over the
Correction.
instruction. Hand over the slip now at the time of
Mention, my lord, this
when
is
the
my
matter
lord.
appears. It will appear very soon. Give.
My lord, only this
What is-
application.
My lord, kindly fix it.
What is the item number?
My lord,
What is the item number?
my lord, 651, my lord.
It is in. Non-prosecution.
651. Go.
March.
Withdrawal. Give.
My lord, may I
Lordship,
have-
kindly allow me to mention one matter, Lordship. It is need to inclusion.
1149. Go. No further. Yes, madam.
Accreditation, my lord, accreditation 1570.
1570.
Just me like just inclusion of the
681. That's 161. Part of determination.
Yes.
Let it be appear on the new motion.
Give the number.
My lord, 671.
1285, your lordship.
Inclusion of the lease, my lord. Yes. Lordship 681 of the monthly list, your lordship.
1285, your lordship, for upgradation.
681
My lord, 671.
1205.
1285, your lordship, for upgradation.
1723. All right.
1475 for upgradation of senior citizen. One 1475.
All right. Go.
My lord, may I have your lordship?
Your lordship, 1285. Your lordship,
1179.
1587, your lordship.
No, for the inclusions. Bolun ki ব্যাপার?
May I?
My lord.
I am not. There is no possibility of getting a matter heard prior to the vacation. Please do not mention. There are other benches. Why don't you try? Go try some other bench.
Madam, 1537 for upgradation, madam.
It cannot be done. Get it heard somewhere else. No inclusion, sorry.
Lordship WPS 7.
Yes.
To mention for Birbhum Jila Parishad one matter, madam. But
What do you want?
only application, madam, because
Yes.
toll is continuing even after the expiry of the
Very well. This is for vacating. Application.
disposal. It can be disposal also.
How can it be disposed
Because-
here without hearing?
Already interim order was there, but tender period of the tender has expired.
Period of the tender has
Yes.
expired.
Alert work order is going to be issued, but could not be issued due to interim order.
And who is your other side?
Other side has been given notice.
Take back the notice. Don't hand over the notice.
Both the notice. I have annexed it.
Notice is not required.
Right.
Otherwise, notice will go somewhere. Should
I have the notice.
You have it?
I have.
All right. ঠিক আছে। এটাকে to be mentioned হিসেবে দেবেন।
এটা
To be
দেবেন।
mentioned হিসেবে দেবেন।
My lord, I'm
Lordship WPS 7.
upgradation, my lord. Item number 1285.
Please,
My lord, kindly, my lord. I'm praying for upgradation.
May I?
7563.
My lord, may I have? My lord, may I have your lordship?
Sorry,
My
sorry,
lord,
sorry. For half an hour, this is continuing.
Renewed, my lord, mentioning with
Yes.
this is a lookout circular without any basis that has been served. You know, it's coming up as 597 in the list. I'm only praying for upgradation, my lord.
Why didn't anybody mention?
Lord.
For more than 30 minutes only upgradation.
May I only?
Lordship, I am from
I'll leave it to you, Lordship.
My lord.
Just look at the list, the number of numbers
I know.
that have been mentioned.
I understand.
Lordship, I
Lord.
am from
No,
virtually.
sir, nobody tried, came forward, nothing doing. No, sorry.
Thank you, my lord.
Item 1 in the original side.
Lordship, I am from virtually.
You appoint a lady member. I'll accept mentioning from the women members tomorrow. You can,
I'll send my junior. my lord.
Lordship, I am from
my lord,
virtually.
my lord, may I have?
any woman friend, lady members
I'm very deep.
tomorrow, not today.
My
Lordship,
lord,
I am
may I
from
have your
virtually.
lordship? Kindly. My lord, may I have your lordship?
Lordship WPS 7563. Lordship, it need to inclusion in the list, Lordship, and need to fix the matter for hearing, Lordship.
Please try somewhere else, sir. No hearing matter will be possible prior to the vacation.
My lord,
Lordship is currently
my
including
lord,
the
some
monthly
matters,
list, Lordship,
my lord,
at
some
least,
matters would be included under the heading for payment of dues, my lord.
Give
Matter
the
is-
pass on the numbers, payment of due, pass on the numbers.
Yes, my lord.
Lordship, Lordship
643.
kindly include the
No,
matter.
no,
Lordship.
hand over a slip. Payment of dues, you hand over a slip.
Lordship, kindly include the matter in the monthly list, Lordship.
Item
Kindly,
number
Lordship.
1, original side.
This is my application, my lord.
Yes, sir.
Regarding the tender process, my lord, where we have challenged the tender process, my lord. Where the tender was accepted after the stipulated time, my lord. Lordship will recollect. I was led by Mr. Bhattacharya in this. The direction of filing affidavits are there. I'm filing my affidavit reply to that.
আমাদের কপি দেবে না
Did you service করা আছে?
আমার
Officer.
affidavit in reply
It has already been served. Don't say all these things. Already everything, sir.
উফ, ভাই জিজ্ঞেস তো করতে দিন একটু।
You send it, then you
মানে
send
কপি
it.
পেয়েছো অ্যাফিডেভিট
Long back.
তো কি করে বলছে এগুলো?
Affidavit service has been given. Always.
Can you show any acknowledgement?
Yeah, we'll show it.
My client, my advocate says that it has not been served, and you say
I am saying before this court that I have served it. I have produced the document.
Milord, serve it and already served.
It's been served. It's been served.
শোনো যাই হোক,
I'll show you
Milord,
document.
I do not understand
Affidavit,
how
where is your opposition?
my advocate on record says that
In the department? All right.
And I filed
You
it
are
back with
for
Respond number 5 is private.
respondent number 5. All right.
Milord, the
What about
private-
the WBSIDCL?
I represent WBS.
Where is your opposition?
Submission will start coming, Milord.
Yeah, exactly. Milord, we have not filed it.
Why?
But within 2 days, I will file it. It
What
was
did
sent
you
for
say?
vetting.
It was time to file. I don't.
19th of June.
July.
I'm extremely sorry. The affidavits possibly by the private respondent was filed and they have given to the reply. Milord, I was not aware about this filing of affidavit.
You are not supposed to be aware.
But
Where
anyway,
is
but
your
yes, Lordship is
affidavit?
absolutely loud. I have the copy with me. I can get it affirmed today itself. Because it is WBSIDCL, I send it for vetting through my learned
The
advocate.
time has passed.
Please
To the 10th
come.
of July. Milord.
Within Wednesday, I can file it. 2 days to file it. It's ready with me.
Learned
but
advocate representing
বলছি file করো।
WBSIDCL
দেরি করনি বুঝেছো? হ্যাঁ খেয়াল
seeks extension of time for filing the affidavit in opposition.
মনে করে ফাইল করো আবার লেট করো না।
Stop. The private respondent number 5 has already filed the opposition and the petitioner has filed the reply thereto in court today. Stop. Time to file the opposition by WBSIDCL is extended till 7th August.
Grateful to us.
Reply, if any, by 14th.
Grateful.
If you Lordship, kindly fix it by 12 because Mr. Bhattacharya will be leading me, Milord, in this matter, Milord.
Reply.
Released for further consideration on 19th August.
All right, Baba.
Instead of 19th, it will be can be 20th, Milord.
20th.
20th.
But do not say that it has been served upon me. Lord, they should as it did.
All right.
I was reading my.
May I, Lord, should I also get a copy of this affidavit?
Whose?
Because I have not been served with any affidavit by
You
the
are not required. You come up with your affidavit. Let us see.
একটা লেটার দিয়ে দাও ওদেরকে যে হ্যাঁ give me a copy of that, বুঝছো? Grateful. একটা লেটার
Milord, this is that MSME matter. I appear for the resolution profession. The MSME was supposed to file the report.
Lordship had directed that MSME should file a one-page report indicating as to whether, my lord, the unit was, my lord, an MSME enterprise on the CIRP date.
They have to really submit.
Where is it? Who is appearing?
Mr. Dinda was appearing on the last day.
No, Mr. Prasad was appearing for respondent number 5.
Yes, Mr. Prasad was also there. Mr. Dinda was also.
Neither the state nor Mr. Prasad. Nobody is here.
Nobody is here today.
What can be done? Very difficult. Just see.
Well, then maybe have it today, tomorrow, if it's subject to your ladyship.
None appears on behalf of either the state. Yes, please give. Who is leading you, Mr. Prasad? All right. What does it say?
I'll give it to Mr. Shah. আরেকটা কম। না, ঠিক আছে, হয়ে গেছে।
Go through it and come back. Mr. Dinda is not here. None appears for the state. Release day after tomorrow. Report by the Joint Director and HOO. MSME. Dated 1st August 2025. Filed in court today is taken on record. Get copy of the same. Get copy of the same be circulated. Day after tomorrow.
One quick submission, Milord. I took instructions after the matter. As at the date, Milord, when the company went into CIRP, Milord, the registration had lapsed.
Yes.
It was subsequently renewed and it continued. And Milord, as at the date when the NIT was published, it was renewed.
Milord, let us
And it
look
was
at the report
eligible
to
on
come
that
back.
date. And that is the date which is relevant.
According to
Your lordship has
According to
Let
Supreme
us-
Court judgments.
Let us
So,
see.
my lord, I have got it all.
Now connotations are changing.
That's right.
Right, let us see. Yes, come back day after tomorrow, please. And somebody please intimate Mr. Dinda so that he remains. Otherwise,
This is my application in a pending writ petition.
The second bite at the same cherry.
Originally, my lord, your lordship was pleased to not to pass any interim order. Against that, my lord, appeal has been preferred. In luck of my client, after I concluded my argument, the following day, Mr. Bose is to argue, determination has been changed. It's gone out of it. In the meantime, a subsequent event took place that tender has been floated. That, my lord, I am challenging before my lord.
Correct.
Now, why I am challenging, my lord? The date for filing affidavit has been expired, not filed. My first point is a decree or an order passed in 2000, whether they can be executed in the year 2025. Law of limitation, whether we will attract or not. This is the first point, my lord. Your lordship was of the view that after affidavit, my lord will be heard that. My second point is that I am a sitting occupant. I am there. If I am there, as per the policy affirmed by your lordship's court division bench, I have a right to first refusal if the tender is made so far as my portion is concerned. Now, what happened, my lord? The entire land, which is a vast area, has been tendered. So, I cannot participate even in the tender, even if I have given this option. That is the subject matter of challenge before my lord.
why can you not participate? Did you mention?
I cannot participate because the circular said
Hmm.
that so far my tenancy is concerned, where I am sitting occupied now, that if is tendered, suppose, my lord, I am in one chair here. If the entire
building is room
tendered, I cannot participate because I cannot quote the entirety of the entire amount. That chair has to be auctioned. That is the division bench judgment, my lord, approving the circular. That's the problem with me, man. And apart from those points which are there, limitation act applies. If limitation applies, Article 138 come into play. More than 12 years, you cannot execute a decree. Those points on merits, I can argue before my lord. Now, for the time being, my lord, I am seeking, my lord, this protection. As my lord, no affidavit. Has
Then how can the authority be stopped from proceeding with the auction of the whole thing if they want to leaving only your chair?
That is the, my lord, that is the circular. If you lordship want to, I can.
Let me see.
But kindly.
What is your stand? Can you are.
Well, I have to first factually correct Mr. Basu, my lord.
Yes.
First factual correction is that he is a tenant of an unauthorized subtenant. He is a tenant of an unauthorized subtenant.
So you do not recognize him at all?
I cannot. In law, my land policy guidelines does not authorize me to recognize a tenant who's an occupant of an unauthorized subtenant. And the division bench judgment that they are talking about, which is a part of their application, kindly have a look at the division bench judgment.
All right.
Nothing does not remotely help his case. And on the contrary, my lord, this stand taken by KOPT has been approved in the division bench. My lord, what the division bench judgment says, which is
You are going for auction of the entire property, possibly
Absolutely.
where a part is.
my lord, my lessee, I can only tender the property which was originally given on lease. Original lease was given to X.
Yes.
My lord, X had unauthorizedly sublet the property to Y. Now Y gave it to Z. So the
portions.
In portions. So now this is an inter se arrangement between X, Y, and Z. Now I cannot isolate or segregate portions and go on tender. My land policy guideline does not authorize me. So what I am doing is the entire leasehold land which was there earlier, my lord, after the eviction order has been passed, I am putting that entire land. This is public land. 15 crores is due by way of areas of rent.
Yes.
Kindly take my application in the order, the application itself. I have quoted I have annexed, my lord, the division bench judgment. Page 14, it starts. Starts. Kindly come to page 23 of that judgment.
প্যারাটা বলবে একটু
Right.
প্যারাটা
না, প্যারা তুমি এই কাগজ নিয়ে এসো। প্যারা নেই এখানে।
এই তো প্যারা
এইটার প্যারা।
হ্যাঁ।
Page 23.
Kindly come to its nomenclature notice as well as kindly called.
Yes.
This is the notice, my lord. Kolkata Port Trust has decided to grant first right of refusal to the sitting occupants who had entered into a particular KOPD property on the basis of certain arrangement with the recorded tenant license, but without any approval of the KOPD, who were not ranked outsider or encroachers in respect of the KOPD property. Whether I am coming under the purview or not, that they have to file affidavit and show that you are not coming. Till today, I am in occupation. There is no dispute about that. Now, my lord, kindly proceed.
No, but then you are in occupation under which status?
According to me, I have been inducted by the original lessee. One of the partner of the original lessee inducted me. This is my case.
Yes, but who has given you the permission? Only the lessee's permission will not do.
That is the kindly. May I read once again the packet portion. Who had entered into a particular of KOPD property on the basis of certain arrangement with the recorded tenant. I say I have an arrangement with the recorded tenant and enter into the property without KOPD's knowledge.
Yes.
So, my lord, today that has required to be decided on factual basis whether who inducted me. But today I am in possession. There is no dispute.
All right.
Then, my lord, kindly turn over the page for the only for this purpose I want to show to your lordship. Kindly come to page 24. Last but one paragraph. If there is, if there is more than one sitting occupant, license lessee to the respective area shall be proceeded for willing occupants only on recovery of dues on pro rata basis, provided each space has separate access. I have separate access. This is the only condition. I am willing. I have separate access. And this is the notification of the KOPD who has been approved by your lordship's court division bench.
Oh, that was in 2014. What is the date of this notice? This is in some separate matter.
No, the notification is still holding the field.
The same notice.
Same.
All right.
Subject to correction, there is no other notification up till now on record.
But then they have put up for auction, you say?
Yes, but not entirety. I cannot match. Mr. Bose has just now said it's 15 crores and all. My occupation is only to
No, 15 crores is the areas of rent.
655 square feet and having a separate access. That's the condition. And what they did in this case, my lord, I was in occupation. 2000, my lord, eviction order has been passed in the year 2000. My lord, I have the judgment of the apex court. It says the PP Act is nothing new, only to expedite all records of law holding the field in India has to be accepted to. If that be so, my lord, and also there is a judgment I have shown to the division bench. I have not occasion to cite before, my lord. The Limitation Act applies. If the Limitation Act applies, my lord, 158 squarely come into play. 136 squarely come into play. If it is 136 is applied to, my lord, then you cannot execute a decree is more than 12 years. These are on facts which is pending before my lord. If in the meantime, and in this judgment, if I read this judgment, it's always said that you auction, but you cannot take possession from the sitting occupant prior to his refusal to refuse. If he is not willing, then you can take possession. Otherwise, you cannot take possession. Kindly see, my lord, that part of the judgment.
37 to
paragraph
41.
My lord, kindly come to paragraph 37. As my lord, paragraph 37.
Yes, the right.
The first right of refusal in the tender cum auction is further subject to the compliance of the conditions enumerated in paragraph 2 of the said notice. It has also been the stand of the writ petitioner that they are willing to comply with the conditions under said paragraph 2 of the said notice. I may hasten to add that though the said notice for first right of refusal indicates that to avail the benefit of the same, an unauthorized occupant needs to apply within 6 months from the date of publication of the notice. Neither the appellants nor the writ petitioners indicated the date of publication of the notice. The appellants have not been taken on the ground that the said notification is no more in force. In view of the above, I am of the opinion that the writ petitioners do come within the purview of the said notice to first right of refusal, and the port trust cannot insist on vacating the said permitted as a condition precedent to avail the benefit that flows from the said notice. The division bench of this court had no occasion to consider the applicability of the said notice for the first right of refusal. I do not have any quarrel with the proposition of law laid down in the other judgment cited by Mr. Dotto and Mr. Bandyopadhyay. Therefore, there is no necessity to discuss the said case laws. That the order of the learned single judge therefore does not call for any interference, and the same is accordingly upheld. Here, my lord, additional fact is here a decree which is sought to be executed of 2000. And my lord, kindly see the and my lord, under the circular we have applied, that is in the writ petition. There is no dispute about that also. My lord, one judgment I want to show to your lordship, my lord, kindly allow me to place it. Limitation. Of এটা judgment দে জোসেফ কপি নাই আমার দিবে আছে yes well kindly take this judgment. This is an New Mangalore Port Trust versus D'Souza etc. My lord, kindly come to paragraph 10. Citation type will be done. নিজে লেখা কিনে জানি
তোমার
সেটা কপি দিচ্ছে
ওয়েবসাইটও নয়
এই জানে কি
ইন্ডিয়া কানুন
In fact, both sides agree that the Limitation Act will apply to the proceedings under the PP Act. Once the Limitation Act applies, all the provisions will be applicable to the proceedings under the PP Act.
PP is the
Public Permission Answer Document Act, by which the decree has been passed in 2000, which now sought to be executed, and in fact, without any proceeding, my lord, they have locked my door. And the Supreme Court, my lord, in the judgment reported in 2019 20 Supreme Court cases, page 701, kindly have only one paragraph.
Read out. Read out.
At this stage, we consider apposite to take note of the Constitution Bench judgment of such and such and such. I have another copy of it. That the PP Act does not create any new right of eviction, but it only creates a remedy for a right which already exists under the general law. In other words, it was held that it is only provides a remedy which is speedier than the remedy of a suit under the general law. So it is nothing special. Special is expeditious. All rigors of law are applicable, which includes, my lord, Limitation Act is also been accepted by the court. If that be so, a decree of 2000, my lord, cannot be applied in the case of the Writ Petition Act in 2020-25. My lord, kindly refresh your lordship's memory. One 136.
Seventh is the last day for payment of the tender fee. 8th is the time for online bid.
But I am debarred.
You are?
I am debarred. Because I cannot take the entire property.
Yes, I can understand.
136.
But then, without hearing them.
No, my lord can hear them. Certainly. Kindly once be refresh your lordship memory, section 136.
It's all right, but
and
then
kindly see the decree.
What is the interim relief that can be granted?
My lord,
what have you prayed for?
I have prayed for my stay. Entirety, my lord, I know.
It's not possible, right?
But I have that separate access if that part is secluded. And in the meantime, your lordship can hear the writ petition.
Yes. What can be done?
My lord,
Interim.
kindly allow me 5 minutes, my lord. By the clock, I'll take no more than 5 minutes. My lord, kindly take the writ petition first. My lord, it is well.
Is the writ petition here?
Yes, my lord.
Writ petition must be here.
My lord, it is well settled, my lord. Admission is the best form of evidence. My lord, kindly take the writ petition first.
Yes.
My lord, they are saying their contention is that they should have a first right of refusal, number one, and there should be a tender to suit their purpose, self-induced convenience. I have to now, because they are in unauthorized occupation of a portion, that portion should be tendered separately. So, my lord, kindly take paragraph 8 of the writ petition.
Yes.
The petitioner number 1 had obtained the said tenancy through, my lord, kindly make a note, Agarwal Trading Company, who was a direct tenant under Burn Standard Company Limited. So Burn Standard is my original lessee. Burn Standard unauthorizedly gives the tenancy to Agarwal, and they come under Agarwal. So, my lord, who are they? Rank trespasser. Now, my lord, kindly come to the division bench judgment that.
Yes, just now read out.
My lord, what was under consideration by the division bench judgment? Kindly have a look. My lord, kindly take first paragraph 2 of the judgment.
Yes.
My lord, there was a original lessee was Binani Metals. Your lordship will find that at paragraph 2. My lord, 3 eviction proceedings were initiated from paragraph 2. Your lordship will see, find by, my lord, the port trust against Binani Metals. Now, my lord, your lordship will kindly take the concluding portion of paragraph 2 of Binani Metals, which starts with in the said proceeding, Ashamangal portfolio sought to intervene by making out a case that a proposal for settlement of tenancy in its favor was approved by SMPK, which is Port Trust, and it unconditionally accepted the offer in the year 2000 for settlement of tenancy. Then, my lord, Ashamangal filed a writ, which is paragraph 3. There was an interim order passed in Ashamangal's writ, who had a right of occupation because they was recognized by KOPT. Now, my lord, your lordship will kindly turn. My lord, kindly take the paragraph 4 of the judgment. My lord, this is on Ashamangal's writ, who was recognized tenant. My lord, kindly take towards the middle of paragraph 4. Neither the payments nor the acceptance of payments will create any receipt or equity. So they were directed to pay the entire arrears, equity in favor of the occupants or any of them in any manner whatsoever. These payments will not in any manner diminish or extinguish any obligation of any of the petitioners to pay the Port Authority. Now, my lord, kindly come to what happens thereafter. My lord, kindly come to para 5. 3 proceedings were initiated by KOPT to evict Ashamangal. Now, my lord, then the estate officer held that, my lord, Binani was not authorized to let it out to Ashamangal. So, my lord, the order of eviction was passed that your lordship will see at paragraph 8. My lord, at this stage, my lord, a writ petition was filed, which is paragraph 12. By whom? By Ashamangal, who said that his right in the property was recognized by KOPT. So the writ by Ashamangal, which is there at paragraph 12, my lord, kindly have a look at that. They say that I come within the purview of the definition of unauthorized occupant, and my occupancy having been recognized, I have a first right of refusal in terms of the notice. This was the limited scope of challenge before the writ court. My lord, kindly see the first prayers in the writ are there in para 12. Now, my lord, kindly come to, this is what the single judge held at paragraph 12.
Paragraph 12 is the prayers.
Yes, my lord, kindly take para 14. Para 14 is the order by which the writ petition was disposed of. It was held, my lord, towards the middle of paragraph 14. Your lordship will see there's a sentence. The petitioner should have the right to participate in the tender with the first right of refusal. So this is what the learned single judge held. Then, my lord, kindly take the notice. My lord, there's another previous judgment of the division bench which is referred in paragraph 18, which is the unreported division bench. My lord, the issue was in the previous division bench judgment, you are saying that whether the auction will fetch the highest price if somebody is in occupation. The issue was that I have to take back possession in order to auction it. Otherwise, I will not get the correct market value. So this was the issue in the previous division bench. That's why this division bench said it has no manner of application subsequently. Now, my lord, kindly take the auction notice, which is at paragraph 29, which Mr. Basu had placed. My lord, kindly see what the notice is. This is not a notification, but it is a notice. This was a e-auction notice. Now, in this case also, there is now a e-auction notice. So, in this subject matter of the writ was this other not notice. So, my lord, they stand on two different footings altogether. Regardless, my lord, have a look at the notice. KOPT has decided to grant first right of refusal to the sitting occupants. That is, who had entered into a particular KOPT property on the basis of certain arrangement with the recorded tenant, but without any approval of KOPT. So, my lord, had Agarwal Trading come, my lord, I would have still understood based on this judgment, though this notice does not recognize first right of refusal of occupants, I would have still understood. But this division bench judgment was, my lord, examining whether this first right of refusal was available to a person against whom an eviction order has been passed. So here, now your lordship will see this was, my lord, kindly now come to paragraph 31.
Yes.
My lord, the same thing is recorded. Then, my lord, kindly take paragraph 34. My lord, there was a distinction made in para 34 that the eviction is in respect of the property, not against sitting occupants. Para 34. The combination reading of the first paragraph and the paragraph 2A of the said notice would suggest that in order to come within the purview of the said notice, it is not necessary that there has to be an eviction decree passed against the sitting occupant. As on such and such, it only provides that there has to be a subsisting decree of eviction in respect of the land in question and not necessarily against the single occupant, sitting occupant. So, when the eviction decree could be against the recorded tenant, or if the person who is in occupation has been let out by the recorded tenant, he would also have a first right of refusal. This was that notice. So, when here then division bench held that yes, they have a first right of refusal, so they can participate in the tender, of course, payment of it. So this judgment, in my respectful submission, has no manner of application in the facts of our case.
And in this present case, the
paragraph 8 of the judgment,
auction notice is at page 32.
Well, what they have annexed is not
this
the.
not the
This is, I don't know where they.
The auction notice, whatever
Yes.
we obtained from the website.
Okay.
But this is what they have annexed before the appeal court as well. So, well, the page that is part of the GA, which is your lordship will see the last page.
32.
Yes, my lord.
Plot details.
I can give you lordship a copy. My lord, kindly have a look at. I can give you lordship the notice that we have published.
Is it the same thing? Then do not hand over a double.
I haven't been given a copy by Mr.
It's
Basu.
the same thing, possibly. I can
Lord,
see.
kindly have a look at this.
Yes, which page are you referring to?
Lord, kindly have a look at. The annexure 3 is where the English part of the. My lord, kindly see the annexures first index, which would be at the bottom. Your lordship will find the page numbers.
Yes, annexure 3 is the English portion.
And my lord, the page numbers are there. Page 6, your lordship will see the plot numbers.
Page 6.
Yes, my lord.
Page 27 it starts, annexure 3.
No, page 6, the bottom.
Oh,
your lordship will see the page numbers right at the bottom. This is what has been auctions.
Yes, this is annexure which has been annexed.
Yes. But thereafter, your lordship.
Mm.
8I. No, ওটা জিজ্ঞেস করো। Now, my lord, kindly see who can apply.
And plot number is 104/25.
Yes, yes. The sketch is also there, what we are putting on auction.
Sketch is also there.
My lord, that is there at page 61 is what has been put on auction. Now, my lord, your lordship will find here. Page.
Is the blackened portion being put to auction?
My lord, this portion has been put on auction, my lord. Entirety. My lord, your lordship will see
The whole
there's a
thing?
water body.
Whole, yes, water body.
My lord, what is on top of the water body, the entire portion is put on auction. The entirety has been put on auction.
Including water body? Yes.
তোমাকে দিলে তো water body ও নিয়ে নেবে।
A, B, C, D. Why are these separately marked? A, B, C, D, E.
My lord, that's why if your lordship reads this with paragraph 6, it will be a page 6, it will become clear what is being put on auction. My lord, the entire plot area has been given, then your lordship looks the plot details, which is annexure 1 at page 6.
Yes.
Area to be leased out.
Hmm.
First belt, land area is so much. Then water body area is so much. Belt area is so much. Water body area is so much.
So there is hardly any scope to leave out a portion.
Not possible. Not possible.
For retendering or anything of that
Not
sort.
possible. Not remotely possible. And for whom? A person who's a ranked trespasser under the division bench judgment. If you were a tenant, that policy, in those, at that point of time, that was the land policy guideline. The present land policy guideline does not even authorize us to recognize the unauthorized subtenants. If you have obtained tenancy after permission, like Ashamongol in the division bench, that they were authorized subtenants. So there has to be a proceeding against them to evict them, which was the second proceeding initiated before the estate officer. So, my lord, their locus in the property was recognized by KOPT. So they had a right to seek the first right of refusal. That is why, my lord, while tendering, the notice recognized their right and give them the first right of refusal. My lord, here is a person who is a tenant of an unauthorized subtenant. So he's in law, he's a ranked trespasser. Now, my lord, kindly see what are the conditions. My lord, kindly see the conditions of lease, which is annexure 6. It would be at page 38 of the tender documents.
Yes.
I just wish to draw your lordship attention. Your lordship will see on top, lease period 30 years
Yes.
without any option of renewal. So, my lord, a person who takes the lease for 30 years, so after 30 years, he'll become a trespasser. Now, my lord, kindly take Roman 5. On expiry of the aforesaid period of lease, if the same plot is included in the tender cum auction for further allotment of the lease, the existing lessee may get the first right of refusal for the same purpose in such tender. Nothing more, nothing less. So this is the recognition under the present land policy guideline in respect of tenders which has been floated now.
Yes.
You will have a first right of refusal
So
now.
this is what's going to happen in future.
Yes.
We.
Existing, none. So, my lord, basically what he's saying, the writ court to rewrite the terms of tender and pass an order which is contrary to the existing land policy guideline. Why? Because he's a rank trespasser in a property. He has chosen, my lord, to come in a property and take a tenancy from a person who's unauthorized. So he must suffer the consequence. It's as simple as that, my lord. So, my lord, this application is nothing, my lord, a repetition of their application before the appeal court. So now, my lord, allow me to address the point of limitation. My lord,
Tell
two
me,
things.
In the writ petition, the writ
Yes.
petition is pending, isn't it?
No, I can tell your lordship can summarily dismiss the writ petition here itself. I'll tell your lordship why. My lord, kindly, interestingly, well, kindly take this. My lord, so far as limitation, my lord, what they have said, it's a eviction decree of 2010. 2000. So I am limiting. Now, your lordship will see there are two suits mentioned, interestingly, but the fate of the suits have not been mentioned. If your lordship will kindly take the writ petition once.
Yes.
Well, I'll just address your lordship on the ground of suppression. Your lordship will see there is a mention of a suit of 2013. If your lordship kindly takes paragraph.
Paragraph 13, there is a mention of a final order of eviction dated
Yes.
15th
No,
December.
they had filed a civil suit. There were two civil suits that were filed. One suit was filed in 2013.
Which provision of law?
No, civil suit, a regular suit seeking a declaration of tenancy against KOPT. So we challenged the suit on maintainability. There was an interim order restraining us from proceeding against them or from evicting them. Now, that suit, we filed an application and eventually the application was allowed and it was held that the suit is not maintainable. Now, he is a proprietor.
Property.
There's a bar under section 15 of the Act. Well, civil court does not have jurisdiction in respect of the properties, which is the subject matter of the Public Premises Act. Now he goes and files another suit by another name. That suit is title suit number 1242 of 2022.
A civil suit.
Another civil suit.
All right.
Now, again, that civil suit is by a person by the name of Jyoti Kotas, which is the petitioner here now.
All right.
Interestingly, that suit is filed against whom? Agarwal Trading, his landlord, knowing very well that Agarwal is an unauthorized occupant. Now that suit, he obtains an ex parte ad interim order of injunction saying that I cannot be evicted without due process of law. That interim order was finally vacated in the year 2024.
Right.
Complete suppression in the writ petition. Nothing. Only suits are mentioned. What happened in the suit, nothing is mentioned. And the writ petition is filed in the year 2025. Now, interesting limitation. Mr. Basu said, why limitation will apply? Who says limitation will not apply? So, the 2000 decree, I have been trying to enforce the decree. There are not orders. There are hundreds of orders passed by the estate officer by which they had objected. They had resisted eviction.
The civil suit order.
Civil suit. So I have filed application after application on the basis of which, my lord, orders have been passed about the police authorities to give me assistance to take possession. So, my lord, immediately after I obtained the eviction decree, I put the decree into execution. So from, my lord, it is continuing for the last 25 years. I have not been able to take possession. So, my lord, a public property, eviction order in respect of which has been passed in the year 2000. My lord, for the first time, it has been tendered in the year 2025. So 25 years of public money has been withheld by a rank trespasser. Well,
Did they pay anything?
Nothing. Not a dime, not a dime. Not a penny. 15 crores is areas by way of schedule of rate. I am not even looking at occupational charges. Schedule of rate, but as your lordship is where under the Major Port Trust Act.
The neither the original lessee nor the
nobody
paid.
Nobody.
Original is the government.
Nobody. Burn Standard, Agarwal Trading, because they are in occupation. So nobody is paid a single penny. So 15 crores is by way of areas of rent today.
Yes.
And I'll just show your lordship the paragraphs from the rate. Paragraphs. Well, this is the position. I'll just give your lordship the paragraph from the writ where they have said about the suit. Yes, your lordship will kindly take.
Even before the rent controller or anything, no payment made.
Have no jurisdiction. West Bengal premises section 3, there's an exemption of public premises.
So, absolutely free of cost, enjoying the public property
25
for so
years.
many years.
25.
Look to 166.
166.
Affidavit, my lord, this is from the bar.
166 of the writ petition.
Yes.
You
66 of the. Huh? No, my lord, kindly have a look at the letter of 2014.
Before that also there is one letter.
Well, kindly see, my lord, kindly see the second page of the letter.
Which page is it?
Well, that would be, I think, 167.
All right.
Well, kindly see the absolutely, my lord, on the top of page 167. We have filed title suit number 140 of 2013 before the learned civil judge such and such, inter alia praying for a declaration permanent injunction. So, sir, I'm not wrong on this, my lord. Now, be that as it may, we are interested to be a direct tenant in respect of the land. We understand further that you have levied so many terms and conditions for the purpose of direct tenancy. We are ready and willing to comply with the terms and conditions mentioned therein. Furthermore, kindly let us know the amount to be deposited. So this is by, my lord, your lordship will see by whom? Jyoti Quotas. The same person who has filed the suit in 2013. And we are in 25. And this suit has been dismissed. Not mentioned in the writ petition why the suit has been dismissed. So basically, my lord, a rank trespasser coming before your lordship asking for interim protection in respect of a public land for which auction has been issued. Now they said that I cannot participate in the auction. There is no bar in law. Anybody can participate in the auction.
Yes.
2000 decree ought to be executed into 2025.
Your expression sought to be executed is improper after hearing the submission of the KOPT, it appears.
Can I explain that? Under the premises, Public Premises Organized Occupants Act, there is no provision for a mode to execute. So he need not go to the estate officer nowhere. He should have take possession by force, which now have been done.
Section 6.
Now, my lord, where is the bar of taking possession within the period of limitation, that is within 2000?
Very well, but then I am not inclined to pass any interim order.
Then what will happen if ultimately my lord is with me?
Nothing doing. Nothing doing. It cannot be helped.
My lord,
The authority has to come up with their stand to explain your ground of limitation.
So if tomorrow, my lord, when my lord will be heard it out, then my lord, if it appears to my lord that no, you should not have executed the decree after the period of limitation, when the Supreme Court says Limitation Act applies, then what is the remedy on mine? My lord has to weigh the balance.
Yes.
In an interim stage. That's the only for the purpose of interim application. This is the only thing. And so far as payment is concerned, under the policy, I have to pay. I wrote to them under the policy. You adhere to the policy. I am ready to pay. It is not that I have not said that I will not pay. This is
2014, your letter that has been shown, you intended to pay.
Yes.
Then even in 25, already before that also, we are in 25, you have not paid a copper.
How can I pay?
You cannot pay.
According to them, I have not been recognized.
Right. Now there is an auction notice and it is open for all. Whether you intend
entirety.
Yes, entirety.
Entirety.
It is their property. They will decide whether to tender it in parts or in full.
Question is whether he will evict me. By virtue of a decree.
The writ petition was filed by? What was because you were already out.
No, thereafter it was put lock.
It was padlocked. That means you were out.
Yes. No, my all embedded thing is there in my possession.
Yes.
In the in the premises itself. Are you running business?
Running business, 15 crore is due. Now they'll put it up on auction.
Whatever 15 crore, 10 crores, I don't mind. If under the, my lord, schedule of rent, it is given to me with a right of first refusal, I am ready.
No, no, they do not accept you.
No, that is the question.
They do not accept
That is the
your
question, my lord.
status at all.
Even if I have not been accepted, I am in possession, there is no dispute.
No, you are not in possession, you are out. It has been padlocked.
The padlock is subject matter challenge.
Padlock is subject matter of challenge. You have
challenge.
not been able to obtain and stay from the division bench.
No,
and
I have not. This is not
it
been
is
but this
Not
is
been moved.
this is the notice.
the writ petition.
This is the notice.
This is
The mode of my lord taking possession.
Here it is annexed. Yes, that is under challenge.
On the first day, my lord was not pleased to pass an interim order.
Yes, you
Because my lord thought my lord will hear the amendment.
right. 17 June
Now,
you
if
carried
the,
up
my
in a
precise point of limitation, if ultimately held to be correct, then my lord, what is the remedy?
No, in the
My lord has to concede.
no, in the first day I see it is being mentioned over here. Nothing can be done.
My lord has not passed an interim order.
No interim order over
So
here.
they went in appeal. They could not secure an interim order in the appeal.
This is the situation, my lord. I cannot do it. I
Why
confirm
not?
my submission, bench change.
I understand.
That
but
is also
then-
annexed, my lord. That order is also annexed.
It's all right.
Court has
but then-
recorded.
And then what do? They go and apply for assignment before the Chief Justice.
What
Did
can be
they
done?
mention the matter before the bench, before whom the
Regular
determination changed? They did not.
Regular bench is there.
Yes, they applied for assignment and waited for 15 days. They could have immediately
Yes.
mentioned before the regular bench. So you do forum shopping, and then, my lord, kindly see section 5, subsection 2. It is specifically mentioned how you will.
Please come. Please come.
My lord, may I have my lord's case?
The
May I have my lord's case?
yes, the petitioners have filed an interim application in connection with the main writ petition, praying for a restraint order upon the Port Authority from giving any effect and or further effect to the e-tender floated for auction of the subject property stuff. Acha. For auction na eta korun tender. Stuff paragraph. The petitioners have averred in the writ petition that the petitioner number 1 obtained tenancy through 1 Agarwal Iron Trading Company, who was a direct tenant under Burn Standard Company Limited, a public sector undertaking of the Government of India. Stuff. Burn Standard Company has gone into liquidation. Stuff. The petitioners are occupying approximately 655 square meter of the property and is enjoying the same without paying any rent to the Port Authority. Stop. The Port Authority does not recognize the status of the petitioners and consider the petitioners to be rank trespassers. Stop. The Port Authority intends to put up the property which was enjoyed by the petitioners along with other properties for lease for a period of 30 years. Stop. The petitioners pray for a restraint order in respect of the property which they were enjoying. Stop paragraph. The Port Authority, when the writ petition was moved, the court was not inclined to pass any order in favor of the petitioners. Stop. An appeal for refusing to pass any interim order was preferred, but till date, no order of stay has been obtained from the Honorable Appeal Court. Stop. At this stage, the interlocutory application has been filed. Stop. Paragraph. As the court is not convinced with the status of the petitioners in the subject property, accordingly, the court is not inclined to pass any interim order in this matter. In the interlocutory application. Stop. The respondents, did you file the opposition in the main writ petition? So no, you didn't file.
No.
The respondents are directed to file the affidavit in opposition within a period of 4 weeks, disclosing all facts and figures, along with supporting documents. Reply, if any, may be filed a fortnight thereafter.
Well, opposition will be in the GA or in the main writ petition?
You can file a composite opposition.
Yes,
also.
kindly. The composite.
Composite opposition affidavit in opposition. যেখানে opposition বললাম না, সেখানে composite affidavit in opposition, because no use filing separate. Your stand will be the same in the GA and the writ.
Your Lordship, the auction will abide by the result of the writ petition, Your Lordship.
It goes without saying, there is nothing to mention about that.
Grateful, Your Lordship.
আর ডাকতে হবে না, GA pending. Don't call any other matters.
Lordship will be taking up original site.
No. It's already 12.
Lordship will be taking again tomorrow.
Yes.
What's the reaction to
why was the matter to appear in the list and why was it not submitted in the department? This is extremely unfortunate. The court relies upon the learned advocate and then the paper doesn't come. This is very improper. Please come. By order dated 28th July 2025, the court directed the petitioner and the bank both to deposit the lease deed. Both deposit copy of the lease deed. Stop. Though the bank handed over the copy of the lease deed, but the petitioner failed to do so. Stop. Accordingly, the matter had to be listed under the heading to be mentioned. Stop. Today, copy of the lease deed lease deed in possession of the petitioner is filed. Stop. The same is retained with the records. Writ petition আগে dispose হয়ে গেছে.
My application.
Yes.
You needn't be troubled with the papers. The facts are a little checkered here.
Yes.
See, 2010, this property, KMDA is practically the owner. Grants a lease in respect of the private respondent. Private respondent inducts me as a tenant, and on the basis of an agreement that I'll be the sublessee in respect of the property within 2010. May 2025, 28th of May 2025, I am dispossessed by the bank. There is no panchnama, nothing is given to me. My passport, jewelry, everything in a property where I've been in possession from 2010. 15 years later, I come and get thrown out on the day. All my goods, clothes, most importantly, passport, more importantly, legally, things that were not hypothecated ever to the bank, also was kept under a lock and key. I'm thrown out. I have no privity with the bank, so my articles could not have been hypothecated. That's one bit of it. Then we go, immediately we were advised to file an application under Section 70. That Section 17, we challenged the order by which was made over to us, by which the district magistrate has passed an order. When the Section 17 applications heard the IAs in connection with the 17, bank comes and says that I will not proceed with the sale. On that undertaking, the sale, that application challenging the sale is not touched. The bank goes ahead and takes steps for sale of the property. That's issue 1. The Section 14 order has been upheld to be, has been found to be a correct order by the Debt Recovery Tribunal. This Section 14 order I am assailing before your Lordship on 2 counts. I'll cross the hurdle of maintainability. I understand that once the Debt Recovery Tribunal has found something, how do I come and assail it? That is actually the least of my concerns, because I'm covered with judgment to show that if the order is without jurisdiction, your Lordships have also held, then if it is void, then I can set it up in any court, even in a collateral proceeding. 2 aspects, your Lordship will kindly consider, that the order passed by the district magistrate is of January 2025. Based on this order, the bank cannot take any steps. This order is thereafter extended by the district magistrate under Section 14 purportedly in May 2025. I am attacking this extension on the ground that the district magistrate is functus officio, and therefore the order is without jurisdiction. If it is without jurisdiction, I'm aware of the judgment that your Lordship has passed, and I want to rely on it because the court's understanding based on Seabright is absolutely to the point, with some temerity, if I may say, where your Lordship returns a finding that where the magistrate is sitting on it, the Section 14 applications before the magistrate has not done it within 30 days or 60 days. He's not passed an order. The timeline under Section 14 is not mandatory, it's directory. Seabright, RDJ. But where I have passed an order, then my powers are circumscribed by subsection 2 of Section 14. I have no authority to extend that. But if I may just show the Surfacey Act once, and I'll rely on one judgment passed by this Honorable Court, to show that the district magistrate, after he passes an order, Surfacey, he becomes functus officio. Kindly have a look at Section 14(1). Below that, I have gone to DRT, and DRT has upheld that I will deal with that. That is, in my understanding, the least of my concerns legally. এটা নয়, যেটা উনি order দিয়েছেন, Section 14 কখন functus officio হয় না। Look, kindly have a look at the second proviso to Section 14. Provided also that if no, kindly mark this, if no order is passed by the Chief Metropolitan Magistrate or District Magistrate within the said period of 30 days, for reasons beyond his control, he may, after recording reasons in writing for the same, pass the order within such further period, but not exceeding an aggregate of 60 days. Providing also the requirement of filing affidavit stated in the first proviso shall not apply to proceeding pending before a district magistrate or chief metropolitan magistrate, as the case may be, on the date of commencement of this act. Look, kindly have a look at subsection 2. It is on this that your lordship has rightly returned the finding that if no order is passed, then this 60-day period is directory, which is Seabright and RDGen. I'll rely on my lord's order. But if an order is passed, then he has no further jurisdiction to extend that order. And I'll tell you, lordship, why I'm making the submission. What prejudice do I suffer? In the section 14 application that is filed before the district magistrate, it is categorically highlighted that there is no tenant, nothing in the property. There is a 2019 Supreme Court judgment, which apparently goes against me, that says if there's a tenancy agreement exceeding 1 year, it has to be registered. But in that judgment, I'll place that there is a right that is given to a person who's claiming to be a tenant to go before the district magistrate to highlight his existence or subsistence of a tenancy. Here, the agreement that I've disclosed is actually of a monthly tenancy. And my name is mutated, my rent bills are there, my property tax is there with regard to the corporation. All this is there. Bank makes this false statement in the affidavit that this property is not tenanted and takes this. I want one bite at the cherry where I get to go before the district magistrate and have this looked at by him. Which is why the second affidavit becomes important. Now the bank has to go and indicate that there is a person sitting there on the property. And the law requires another affidavit because non-requirement or dispensation of an affidavit is only with regard to the second proviso situation, where 60 days has lapsed and no order has been passed. There the district magistrate is not functus officio. If your lordship looks at subsection 2, kindly have a look at 14 subsection 2, and I'll show this one how your lordships have considered subsection 2. For the purpose of, for the purpose of securing compliance with the provisions of subsection 1, the chief metropolitan magistrate or the district magistrate may take or cause to be taken such steps and use or cause to be used such force as may in his opinion be necessary. So I have passed an order. The bank comes back to me and saying there is resistance. I'm not being able to employ or get possession. He may direct the police. But where an order has been passed and a date is given to take possession, the bank does not do anything. The district magistrate, in my understanding of section 14, and your lordship will kindly test it, my lord, he has no jurisdiction unto him left by the statute, which is the repository of his authority, to pass another order extending it. My lord, in aid of this, your lordship will allow me to rely on one judgment. Na, Shobhanaji Bhattacharya. Lord, kindly allow me to rely on 2023. I had a copy then now. 2023 SCC Online Calcutta 2155. So kindly have a look at paragraph 4. That's a submission.
Why review? What was the issue over here?
Milord, paragraph 4.
It's a review.
I'm sorry, Milord.
Paragraph 4.
Yes.
The court was considering as to whether the DM had the power to review its own orders.
Yes, that apart,
What
it is
was-
argued that the magistrate becomes functus officio after disposing of the application under section 14 of the Act, and as such acted dehoes his jurisdiction, passing the impugned order. Paragraph 6 also, if your lordship kindly has a look at, Milord, once. Insofar as the prayer made by the learned senior counsel appearing for the respondent borrower for a fresh inventory, it is argued by the petitioner the said prayer ought to be turned down, since the movable properties have already been duly inventorized by the order of the magistrate. It is further argued that the magistrate acted without jurisdiction passing the impugned order, since an application under section 17, kindly mark this, in this case also it was pending, is already pending at the behest of the borrower before the tribunal itself. In the event any order was to be passed with regard to the immovable property, the same could only be passed by the tribunal and not the magistrate. Now, Lordship will kindly turn over, my lord.
Yes.
Paragraph 15 onwards. Hence, insofar as the movable properties are concerned,
Yes.
the same does not fall under normal circumstances within the contemplation of an order passed under section 14 of the 2002 Act. The respondent borrower has cited Noble Kumar, which laid down the satisfaction of the magistrate contemplated under proviso to section 14 necessarily requires the magistrate to examine the factual correctness of the assertions made in such an affidavit, but not the legal niceties of the transaction. It is only after recording of his satisfaction that the magistrate can pass appropriate orders regarding taking of possession of the secured asset. It has been argued by the respondent borrower that by virtue of such an observation, the magistrate is not rendered functus officio even after passing necessary direction with regard to the assets under section 14. As such, it has been contended that a magistrate could very well pass subsequent appropriate orders in connection with the main proceeding. We are required to see the context in which the magistrate exercised the power in the present case in order to decide the legality of the same. Then there is a factual analysis. Kindly have a look at, paragraph 29 and 30 and 31. 28 is for a different purpose, where they have kept my passport also. Passport, my voter ID card, everything. 29, the only possible scope of exercise of authority of the magistrate with regard to such properties can be found in subsection 2 of section 14, which entitles the magistrate to take or cause to be taken such steps as may, in his opinion, be necessary for the purpose of securing compliance with the provisions of subsection 1 of section 14. Hence, while complying with subsection section 14(1) with regard to secured assets, any other steps which may, in the opinion of the magistrate, be necessary can also be taken by the magistrate. However, such power is restricted, please mark this one, such power is restricted only at the juncture when the compliance of section 14(1) is secured. That is when the possession of the secured assets is taken and not thereafter when it becomes functus officio. There cannot be any doubt that after taking steps under section 14 of the Act, the magistrate becomes functus officio for all purposes. Further orders cannot be passed by the magistrate with regard to any property or in regard to aspect covered by the previous orders passed by to secure compliance under section 14(1). Thus, the impugned order is palpably without jurisdiction. It is not only a question of lack of power of review, but whether magistrate could take shelter under subsection 2 of 14, take further steps after compliance had been secured. This is a slightly different aspect where possession has been taken. But the issue is, your lordship has found that once the order is passed under 14, the only extension or only other power or authority is subsection 2. There is no authority to pass another order by the magistrate. And my lord, I'll be candid. We are making the same submission before this honorable court in another coordinate bench. The matter has been reserved for judgment by my Lord Justice Hiramaya Bhattacharya. This issue is at large there. This is the sole issue there. Now, in this matter? No, at Onnumam. Look, I have only argued that and that is there. So, if I look at the judgment that your lordship has passed, relying on Seabright, Lord, if I may just rely on that.
No, that is only regarding the time period within which Section 14 authority ought to act.
That's right, my lord. So I want
It's
to
only
rely on that.
that.
Your lordship has rightly held.
See,
that
today you are concerned with your movable articles, your passport, your documents, and your jewelry and
I
everything.
am assailing the Section 14 order by which possession has been taken, being completely without jurisdiction. And the purpose why I'm making the argument is what I just told your lordship.
Yes.
As a tenant, now if your lordship holds that this possession ought not to or could not have been taken by virtue of a second order that he's passed, extending the first.
But this can be, this observation can be arrived at by the tribunal also.
That recovery tribunal also.
Yes.
But here, my lord, I am questioning the jurisdiction itself.
There also you have already, it is already.
But this point I have not assailed. My lord, the jurisdiction aspect, I'll probably be able to get out criminal password. Lord, if I may formally cite this, my lord, it's very oft-cited judgment that I can take the point of jurisdiction in any proceeding. Even
Very well, it is there. It is already there. Your movable articles is the first concern. What will be the stand of the bank with regard to the movable articles?
Sir, if they want, we can hand it over.
You can.
Yes.
All right.
Because that is not charged.
Not charged.
But first, my lord, with regard to maintainability, I have some.
Yes, we are not going into that. The movables, let the petitioner take back the movables.
Time within 3 days, we are ready to hand over.
Take the movables first.
But
You have a list.
Yes, we've disclosed that.
Where is it? Where is it?
It is not with them.
No, the list I have disclosed.
Where? With the bank or with the writ petition?
In the writ petition.
In the writ petition, there is already a list. All right. And since they were already occupying it, they may have other articles also.
And we do not recognize that.
Maybe. But then there may be other articles also which the petitioner may be required
Possession has been video.
over and above whatever is here. So let them go and take. Yes, let them. Yes, let them go and take back the physical possession, not physical, the movable articles, and an inventory list will be prepared on the spot along with videography.
Rightly instructed, my lord. Please have a look at what is the condition of the property. They've left the main door also open. We've taken pictures from outside, and that's the picture.
So you mean to say there is nothing inside?
What will be? I'll go and take, but what will be there?
I do not know. You say everything.
They've not even put a padlock. They've kept it open because they don't care. The bank is a very privileged entity. They've not even, they know, and he very fairly, I have nothing against him. He very fairly submits that this is not hypothecated. Kindly see, forgets what is there. He's not even put a padlock on this. I have standing outside on the road and taking a picture of my own house. It's open with all my articles inside. What will be remaining at night? I don't think, they don't even have a security guard. Passport, jewelry, AC, fridge, everything. It's my
Just
house.
go and see.
First of all,
My list is already there on record, page 130.
Second, he moves the section 17 code, does not get an order, fails to get an order. It is specifically, even they have disclosed that stay was refused. Secondly, the DRT holds that the document which they are relying on is an unregistered document. So, my lord, it might be a case that the document is manufactured, or I do not want to go into that aspect now. Now, whatever is there, since I admit that if at all a single piece of paper was inside, it is not hypothecated to us. Whatever is there, if it is there, it should be either.
At the time of taking physical possession, did you? It was.
Kindly record this, my lord.
All right.
So you. Keeps it after a week. Let me go and take whatever is there. If they've videographed it, will be
If
there. I'll
at all
cover that.
anything is there.
If anything is left.
This is a day within which they have to, but beyond that day, we should not be held responsible for any of the articles there, because it is not our property. The articles lying inside.
Who is in possession of this property now?
The authorized officer.
And you've not padlocked it.
That I have to take instruction. I do not know what.
And what is this? This stand that after 3 days I will not be responsible.
Because
they're
go and
sitting
take
with somebody's
possession.
property.
Go and take the movable goods, whatever is lying over there. How soon? 1 week will be all right with you?
Yes, yes, Manoj. Kindly keep it after a week. We'll
After
come
a
back and that videograph that they have, Manoj, let that also be shown to me. So at least I'll be
Yes.
able to.
Mm,
Well, the possession was taken by the representative of
when was it taken?
On 28th of May, 2025.
So more than 2 months over already.
Over with a property with a road.
And you think the jewelry and everything will be over there?
that I do not know.
How will he deny that? If he's taken a video, if he's done a video, let that be shown.
The possession was taken in presence of police by the representative of the district magistrate.
And did you make an inventory of articles which is inside? Which is inside?
Whatever are there, inventory is usually prepared.
So nobody signed it. He should have made me sign that.
No, why would he?
Oh,
We have no.
You
My
have something
articles.
in your possession, your inventory list.
That I have to take instruction.
Must be there.
We
let that come at least first.
You must have almirahs and everything inside.
Yes, I have a full
Did you
list.
open the almirahs?
We do not accept his contention at all. We say that we have taken possession of
Assuming you come up with your list first,
Yes,
then
let
you
them
go
show that
because
in-
more than 2 months have gone.
Yes,
It's
yes, Manoj,
hardly.
let them show what inventory they have done
Acha.
in respect of this.
My signature has to be there.
And Manoj, only one aspect, Manoj, I don't know who had appeared for the bank, but there was an undertaking that they will not sell the flat, this property.
with that auction. The auction that was proposed to be held on a particular day because there was no bid. But
So it failed.
so it failed. But there would be further attempts.
But right now
let
there is
us-
nothing.
He has chosen the section statutory.
The
He will have the liberty to.
matter relates to mortgaged property, which is a flat measuring 1295 square feet. Super built up area in the first floor and a garage measuring 5 meters into 3 meters. In the ground floor of premises number 1885, Rajdanga Main Road, PS Koshpa, Kolkata 7000107. Stop. The petitioner claims to be a tenant of the subject property. Stop. Paragraph. The bank has taken over possession of the said flat under the provisions of the Surfacey Act 2002 on 28th May 2025. Stop. According to the petitioner, all their articles and movable goods were inside the subject flat. Stop. The bank has forcefully dispossessed the petitioners and taken possession thereof, along with all movable goods. Stop. The petitioner challenges the action of the bank in taking over possession, relying upon order passed by the district magistrate under section 14 of the Act. Stop. The proceeding under section 14. Now, the steps taken by the bank is already under challenge in an application under section 17 of the Act, which is pending consideration. Stop. The petitioners have failed to obtain any interim order in their favor. Stop. Next. The petitioner firstly intends, now the petitioners intend to take back their movable articles and documents which were kept inside the subject flat. Stop. Learned advocate representing the bank submits that The process of taking over possession was duly videographed and an inventory list of the articles therein was prepared. Stop. Let the videograph and the list of articles which were available inside the flat at the time of taking possession be produced before this court. Friday? Today is Monday. Friday. On Friday. 8th Tarikh. 8th. Stop. The would you bring that in a pen drive?
May I prefer one indulgence? If you could share that with us on Friday and we could come and trouble your lordship on Monday.
All right.
Then I won't have to.
Very well.
We'll share that by mail or something.
Then prior to that day.
On Friday, if you could just give it to us, and
All right, then Friday, then weekend they can go through it, and
Monday we can come back.
That we deny at this stage, deny the allegation.
all right. Acha. The videography may be shared by the bank over the email ID to be handed over to the learned advocate representing the bank. Stop. Release the matter for further consideration on Wednesday 13th. আচ্ছা, যেখানে ব্যাংকের সাবমিশন আছে না, ওই জায়গাতে লিখে দেবেন the learned advocate for the bank denies the allegation of the petitioners. Stop. আচ্ছা, paragraph. The maintainability point raised by the bank is left open. Stop. This order is passed only for the petitioners to actually see the videography and make submission with regard to the movable articles which the petitioners claim were there inside the flat when the possession was taken.
If your lordship has directed me to share things either by mail or by once they go through, if your lordships direct them in presence of our officer to inspect the flat before it is presented before your lordship, I feel.
Well, let us just have a look at it and come back.
Thing is, inspection first, let them see what is there, then only inspect. Otherwise, what is the something more is left, you say, because the submission is that the door is open.
Is there pictures?
But we are.
Well, may I just pray for one thing? Well, would it be your lordship pleasure to record his submission that he is very fairly said that these articles and documents are not hypothecated with? Kindly record this. It'll.
See, even if it is not recorded,
they actually not.
They are not. So what is the use of recording all these things? কি বললাম?
Superfluous.
কি বললাম?
Videography and make submission with regard to the movable articles with the petitioner's claim
to be there at the time of taking possession. Let us see, and then if anything can be done.
Very good.
Item number 3.
Right, I'm for the petition. As per your lordship direction, I have served the Union of India. Now my
for number 2. Respondent number. Who is the respondent number 2? Respondent number 2 is the Union of India. No, madam.
Union of India respondent number 1. My letter.
Paid by Priyanka Tribunal. And I'm praying for notice with that we don't have any instruction from the ministry. I'm appearing on behalf of the Union of India.
But the
Yes.
problem is there is a development in this case. But your petitioner is an OCI and came with 2 children in India. Now, my late 17 years boy has been permitted to deposit the fine, but minor daughter, who is 11 years plus, her application has been rejected. Now, my late, after depositing the fine, we have to
Who has permitted?
minor son, if FRRO.
FRO has permitted.
Yes, ma'am. Then we have to deposit the fine along with the ticket. Thereafter, we have to upload ticket. But my lord, after depositing the fine, there is no cut-off date. Now my minor daughter is left, and there is no cut-off date. This is the problem, my lord.
Cut-off date means within which you are to return.
Yes, and which within which I have to pay the fine.
All right.
If they block this fine amount, then we will be again in trouble.
How much is the fine amount?
69,920.
Very well. You have to come back with instruction. The fine amount may increase because of your delay in taking instruction. But then what will happen to the fine amount? 69,000 have been directed to be paid. By the time you come back, it will go up to 89,000. Then what is going to happen? So no further increase of the fine amount, I tell you. Please come.
Well, the cut-off date is not there. This is another issue.
Learned advocate appearing for the petitioner submits that the foreign regional registration officer has permitted the minor son of the petitioner to deposit fine. Let me see the document. Where is it mentioned fine?
Well, at the bottom.
At the bottom. Fee it mentions. Penalty fee.
Yes, ma'am.
Directed to deposit penalty fee.
My lord, that is
Penalty fee for what?
exit permit.
Is it mentioned exit permit?
Yes, my lord, that is illegible, my lord. Kindly.
Which portion you say?
My payment request, thereafter services, thereafter exit permit. In the bottom, my lord.
Payment request I can see. Payment request is here.
Yes, my lord.
Then where is the
my lord, above this, my lord, exit permit.
Exit permit.
Yes, my lord.
আচ্ছা কি বললাম? Penalty fee for exit permit for a sum of rupees 69,920 only. On, give me the date, 29th of July 2025. ঠিক আছে? Submission is that the request of the minor daughter of the petitioner has not been accepted till date.
Yes, ma'am.
Rejected.
That has been rejected.
Not accepted and rejected. Till date happen and rejected. Stop. The petitioner is also here or he is outside?
He is here. He is OCI.
Yes.
There is no bar.
The what is the prayer in your writ?
To allow the prayer of the petitioner's daughter for exit permit.
The petitioner intends to obtain exit permit for his minor children. Stuff next. Learned advocate representing the Union of India seeks time to take instruction. On such prayer released on 11th August 2025. Stuff. Positive instruction shall be taken with regard to the time period within which the penalty fee for the minor's son is required to be paid, and the reason for refusing the prayer for exit permit in prayer for issuance of exit permit in favor of the minor daughter of the petitioner. Have you followed? What is the instruction that you are required to bring?
Yes, my lord. I'll
All
go
right.
for the order sheet also. Yes.
So please bring that. Service is taken on record.
Grateful.
Grateful.
What should I appear for the state?
Respondent number 4. All right. Yes.
My lord, this is in regard to appointment of primary teachers as booth level officers by the Election Commission. Now, my lord, all the petitioners with your lawsuits are primary teachers. All. There are, I tell you, lawsuits.
Election Commission of India, is anybody there?
I represent.
Election Commission of India. All right.
Now, my lord, kindly see the appointment letter at page 41. One of the appointment, there are little variation is there in letter of appointment. Your lawsuits will find this has been, my lord, appointment letter has been issued in terms of section 13B subsection 2 and section 13CC. I will take your lawsuit section 13CC. Before that, I just place before your lawsuits. After the box column, he or she is appointed as the booth level officer against the polling station specified in column 1 of the above table, and following terms and conditions are imposed upon him. After rationalization of polling station, the name and number of the polling station will change. Keep the polling area almost same. I request your lordships, kindly see the nature of duty one after another. I will not read out your lordships. Kindly just go through your lordships the number of duties assigned to me. Up to at least your lordships, handling of multiple entries, door-to-door visit, electoral roll maintenance, special campaigning days, present at the polling station. My lord, according to my assessment, it's a full-fledged day-to-day work. It's not for holidays or all that. Now, your lordships, kindly then your lordships, I'm a primary teacher. My lord, kindly see the last column. Please note that section 13C, that section 13CC of the representative, your service shall be deemed to be on deputation to the Election Commission India, and you will be held responsible and accountable for any negligence or breach of official duty. Any such action shall be firmly dealt with under the provision of section 13(2). Lord, I request your losses kindly go to the section 13C. CC. 13CC. Exactly in the same term. Now, my lord, as we have learned from the law college, deeming provision is stronger than the normal provision. So I am under the, my lord, as soon as this appointment letter has been issued, I am under the Election Commission. I am on deputation. My lord, in common parlance, in service jurisprudence, deputation means from one cadre to another cadre, from one department to another department. My lord, does he suggest, therefore, that I am not to discharge school duty? I'm putting a question to myself. Considering the nature of duty and the provision of the Act. My lord, the Act kindly take note of a specific period. Here, the appointment letter do not specify any period. Your lordships, there is a language, your lordships, specific period. If I'm, my lord, I take you, my lord, good. My lord, 13CC. The officers referred to in this part and or any others employed in connection with the preparation, revision, and correction of electoral rolls and the conduct of all elections shall be deemed to be on deputation to the Election Commission for the period during which they are so employed. This is lacking in the Malad appointment letter. They have not dealt with. They have only Malad said it. The work means revision of electoral roll. Your losses can level look at it. This is for revision of electoral roll. Malad, the very first special summary revision, very first nature of work. So I have been employed by the Election Commission for revisional of electoral roll.
Where do you get that revision?
What your losses? Presence at polling station.
Presence at polling station.
Present at the polling station during the entire period of the special summary revision. And section 13 CC says that, my lord, for the revision of electoral roll. So, my lord, my first submissions, this is not clear. Where am I to work? I have no objection to that. But I cannot, my lord, discharge dual duties like this.
What is your school timing?
My lord, school time 10 to 4.
10 to 4.
10 to 4.
All right.
This is one of my submissions. Well, then your losses kindly consider this. This came up before the Honorable Supreme Court. I take your losses one. Then I will show how the Election Commission sought to amend it. Well, this is reported in 2008, Volume 2, SCC, page 390. Paragraph 29. Only one paragraph I will rely upon before losses. Kindly similar to section 29. With an advent of technology, requisitioning of a large number of people for carrying out the election may not be necessary. We may notice that the Election Commission has different roles to play. Preparation of electoral rolls, revision of electoral rolls when objections are filed, hearing of the parties and determining the objections, enumeration of the voter list to hold election as and when due. The Election Commission and its officers, in our opinion, can formulate an effective scheme to see that the services of a large number of teachers are not required. This is the objective lawsuits. The state admittedly is not in a position to perform its sovereign function of imparting education. Such functions necessarily are required to be performed by private actors. Those students who are in a position to get admission in public schools, presumably who also be in a position to appoint tutors, whereas those students who are admitted to the government schools ordinarily would be from middle or lower middle class or poor families. The state of primary education in India is in deplorable condition. There admittedly is heavy dropout from the schools, particularly from amongst the girls' schools. The question if right to exercise franchisee, whereupon the emphasis is laid by Mr. Venugopal, is an important one. The right to education is also no less important, being a fundamental right. But after this jolt from the Supreme Court, the Commission has from time to time issues order, not like a comprehensive scheme. I will take your losses to the last order of the Election Commission. Your losses kindly take up the last one at page 71. The others are there, Malad. I think, Malad, this is because the last one in the Election Commission will respect their own regulations like this. 71 year losses. It starts 4th October 2022. Now, your losses kindly take note of this in the second page. Booth level officers can be appointed from the following suggested list of categories: government or semi-government employees. They have put the teachers first.
Which portion are you reading, please?
Page 71. The last office order or their orders,
All right.
comprehensive instructions.
Yes.
This is of 4th October 2022. The bottom at the page, appointment of booth level officers. Booth level officers are to be appointed by the electorate registrar officer under section 13B2 of the Representation of the People Act 1950. After obtaining approval of the district election officer, they shall be deemed to be on deputation on the Election Commission of India under section 13cc of the RP Act 1950. Then you'll see next page. Booth level officer can be appointed from the following suggested list of categories, government or semi-government. Teachers have been put at the top. I don't know whether it is in consonance with the Supreme Court views or not. Then your losses, kindly see the next page. Page 73, continuation of the same. Following points should also be ensured before deployment of BLOs. Point number D. Teachers shall be drafted minimally. I have an averment in the writ petition that in a particular block, 90% of the teachers are BLR or primary teachers. 90%. I can give you lots of the data I have. Therefore, their own action, we have to read together. Even if you have kept the teachers at the top, that doesn't mean the teachers has to be recruited first. I should, according to the judgment of the Supreme Court, teachers to be the last.
Maybe possibly because of their status. See, the Anganwadi workers comes there, then Patwari, Panchayat Secretary. That is the reason.
Maybe your lordship, but therefore, this has to be with clause D.
Yes, clause D.
Teachers should be drafted minimally as both level officers. However, where necessary, they should be drafted for both level of during holidays and during non-teaching hours and teaching non-teaching days. Is it possible to use number of work? I know, this is an exigency. They have the power. But the power doesn't mean that has to be exercised arbitrarily.
All right.
Then your losses will find my paragraph 7, page 19. These are the averments of the writ petition.
And are they the primary teachers in government schools?
Aided school, all primary school are aided.
Aided schools.
Local government. Council is a local government. Page 7, paragraph 7, page 19.
Does the schools have students over there?
Students are there, as usual.
Because hardly primary schools.
It affects pupil-teacher ratio also. I will show one judgment of our High Court. If it affects the pupil-teacher ratio, you cannot.
Yes.
Paragraph 7. Your petitioners found that in some constitution, more than 90% of appointees are the teachers. I am giving you, lordship, page 56 of these annexures. That is Nabadip constituency. It starts from 51. 90% are teachers. And another one, 51 is Bamunghat Bhangur constituency. 90% are teachers. And it affects the pupil-teacher ratio also. This point that 90% teachers appointed, rather the point in regard to pupil-teacher ratio, came up before this honorable court once. I give you lordships this is unreported copy. Ektu Joseph I am to show
Yes.
This is only kindly see the present writ petition has been preferred challenging inter alia and order dated passed by the respondent number 5. This says that all are respondent number 5 is a teacher, section 13cc, as I placed before lordship qualifying date. Lordship, take a cursory glance, straight away come to page internal page 5 of the judgment.
Yes.
Undisputably, there are only 2 primary teachers, including the petitioners and the said school, as mandatorily required under the provisions of the RT Act. The guidelines which have been framed by the concerned ministry do not suffer from any jurisdictional error, inasmuch as the same have been framed on the basis of the authority conferred under section 35 of the Act. For implementation of provisions of the Act, duties relating to elections to the local authority of the state legislature or parliament in section 27 of the RT Act have been explained by the guidelines, stating that the state duties relate to conduct of election and the consequent deployment of teachers on the days of poll and counting, the time spent on training imparted to them, and collection of election materials for such deployment, and that all other duties relation to electoral revisions will be undertaken on holidays and during non-teaching hours and non-teaching days. As such, argument of Mr. Chaudhuri that the guidelines do not pertain to implementation of the is not acceptable by this court. The argument of Mr. Chaudhary that the conferment of the benefits to the petitioner would open to floodgates is also not acceptable by this court. Only because there is a possibility of floodgate litigation, the valuable right of a citizen cannot be permitted to be taken away. It is well known that a decision is an authority what it decides and not what can logically be deduced therefrom. Even a slight distinction in fact or an additional fact may make a lot of difference in decision-making process. The questions answered by this on Supreme Court in the Gujarat Assembly elections reported in, as now I have shown to your lordships, have no application in the present case. It is true that the judgment in the case of St. Mary's was delivered prior to the comings of the RTE Act, but the issue urged in the same is identical to the lease involved in the present matter, and answering the issue as to whether the service of the teachers of the government school during school times can be utilized for election purposes. It is categorically observed in paragraph 33. We would, however, notice that the election commissions before us categorically stated that as far as possible, teachers would be put on electoral revision works on holidays, non-teaching days, and non-teaching hours, whereas non-teaching staff would be on duty anytime. We therefore direct that all teaching staff should be
Yes,
put
I have read it.
So therefore, your lordships kindly also see the Right to Education Act once. Well, Section 27.
Let me hear the election commission. What stand they have to take?
Please come to page 41. Booth level officers, they are appointed for collecting actual field information. Please come to page 41.
41.
In pursuance of the provision of subsection 2 of section 13B of the Representation of People Act 1950, read with the Election Commission's letter of 2006 and 2016, the electoral registration officer for so and so assembly hereby designates in consultation with district election officer, the officer of the state government, local body or educational institution specified in column 2 of the table below as the booth level officer for the part of the electoral roll under so and so constituency in the state of West Bengal as specified in column 1 of the said table against such officer, state government, local body or educational institutions, then not the duties are prescribed. So it's not a unilateral decision that the commission has taken. It is done in consultation with including officers, including the school. Not the best authority to decide as to whether a student, and not, this is probably a misapplied misapprehension in this case, because if your lordship kindly comes to page 73 of the writ application, now this is not being done after declaration of election this time. And this is why not all the judgments not which your lordships have been pleased to consider thus far is probably once the election notification is made declaring a date of election, then the process continues or commences. Now this is done at least 6 months prior to the date of announcement of the election process this time. Please have a look at page 73. Now, 48,000 have already been drafted, out of which 50 are today or before your lordships only. Page 73, clause C, clause D. Teachers shall be drafted minimally as booth level officers. However, where necessary, they should be drafted for booth level officer work during holidays and during non-teaching hours and non-teaching days so as to avoid any loss of academic work. It must be ensured that no teacher of a single teacher school is deployed for this purpose. Now please come to clause J on that page, the last clause. The activities for BLOs should be planned in such a way it does not affect the working of their parent department. So they have probably been, what probably affects them is they might be called on holidays or not.
It's an apprehension.
It's an apprehension.
That they may be called.
May be called.
This is in general an order, page 41. As of now, duties under the Representation of People's Act have not been allotted to any of
as
the
of date.
officers.
But if they will be allotted, they will be done not following for the teachers,
Following
not following this guideline. And what this is done in consultation with the schools.
And in line with the Supreme Court order.
And the Supreme Court judgment.
Which also says.
And what this is the first time that this drafting is done Much
Prior
before the
to
date of
date of-
announcement of the election. So all competing circumstances had been weighed and taken into consideration.
And this work has not started as on the booth level officers work.
They will be deployed. They will be deployed for training, and then they will be put to work.
And training also on
Oh no,
the
holidays for them.
holidays
Yes,
and non-working hours.
Not affecting anybody's service conditions.
So you have to work double time, double shift.
But probably work for the first time.
No, my lord, this is physically possible, my lord.
What do you say? It's not possible. The act requires your service. The nation requires your service. What can be done?
I tell you, lordships. I'll tell you, lordships. Workers of the financial institutions and works of the teachers are put in a different footing when the election commissions needs us. There is a blanket prevention on regard to recruitment of finance or employees of the financial institution, as good as teachers. Now, my lord, here I told you, lordships, I will be on deputation. Deputation means for what purpose? Only for a specific work or for the entirely I'm under deputation?
No, it's not entirely.
Now, my lord, if it is not on entirely, then your lordship, this is for only for these specific purposes. I'm deputation. Now, my lord, deputation, my lord, if I'm on the non-working day, my lord, school non-working days,
Yes.
my lord, only Sundays. Is it possible to do that?
Why not?
My lord, how?
They will allot work in that manner because you have not been allotted work. This is the list of work or the nature of works that will be required. You have not been allotted any work now.
My lord, your lordships kindly consider that all of the works to be done by me.
All is not required to be done by you.
Lord, that's the work, your lordship. It doesn't say that.
Yes, it is the work. A limited work will be given to you. You are apprehensive of doing work.
No, my lord, apprehensive.
You do have Saturdays as working days in the court now.
Probably my learned friend every Saturday comes, I believe.
Did you work?
Did you?
No, nobody comes up, my lord, before lordship. Justice Mohitos Mojumdar first hold in the court in the primary school matters in Saturday.
Listen.
Consecutively.
Yes.
So this is the one or two examples,
Yes.
not that regular. Now, my lord, all that I am saying, my lord, this is the nature of duties. Why they do appoint the teachers only? My learned friends, 48,000 teachers.
There will be other workers
There are
also.
no others.
They will take.
There are no others.
You are not required to be so apprehensive. They will allot
No,
jobs
what
to
does-
you during holidays and during non-teaching hours. No, nothing.
There is, kindly record that your losses during holidays.
Yes.
Record that.
Yes.
Guidelines.
Following the guidelines, not this.
Following the guidelines.
And
Following guidelines is vague.
the petitioners are primary school teachers. Stuff. They claim to be aggrieved by the order of the electoral registration officer of 180-Pagnan Assembly constituency dated 24th June 2025.
Is one of them. That is one of the letters. Similar letters for some of
Or letter for others. Acha, acha. Tale electoral registration officer. Are the dates same?
No, varying dates.
Oh, varying dates. Acha, tale date tao deben na. Of various dates. Dates of various dates passed by the electoral registration officer requiring their services under the provisions of section 2 of section 13 caps B of the Representation of the People Act, 1950. Stop. Next. The petitioners are apprehensive that না ওটাকে কাটুন তার আগে লিখুন the order specifies that the officer will be appointed as booth level officer BLO caps against polling stations under the terms and conditions as imposed upon them after rationalization of polling stations. Acha, upon them for full stop. After rationalization of polling stations, the name and the number of the polling station. এটা দরকার নেই, after rationalization কেটে দিন. The officers are required to report progress and issues to the electoral registration officers for timely resolution, and their services are to be deemed to be on deputation to the Election Commission of India, and the officer will be held responsible and accountable for any negligence or breach of official duty. Stop. The services required from the officers are assisting eligible citizens, their presence at the polling station on the designated special campaign days and during the entire period of the special summary revision, except on holidays under the Negotiable Instruments Act. Stop. Special campaign days, electoral roll maintenance, door-to-door visits, polling station verification, handling multiple entries, consultation with political parties, and address standardization. Stop. Paragraph. The petitioners apprehend that as they are required to teach students in the primary school, which is a whole-time job from 10 a.m. to 4 p.m., they will hardly be left with any time to perform duties as per the order of the electoral registration officer. Stop. Paragraph. It has been submitted that it will not be proper for the officers to absent themselves from school duties only for the purpose of acting under the direction of the electoral registration officer. Stop. The studies of the primary school children will be hampered if the teachers are allotted any other duty apart from teaching. Stop. The student-teacher ratio under the Right to Education Act will also be infringed if the teachers are deputed for other duties. Stop. The paragraph, the petitioners relies on the judgment delivered by the Honorable Supreme Court in the matter of Election Commission of India versus St. Mary's School and others, reported in 2008 to SCC 390, and the unreported decision passed by a coordinate bench of this court on 28th September 2018 in WP number 18225W of 2018, within bracket, Shutantra Haldar versus the state of West Bengal and others. Stop. Prayer has been made. Oh, character line. It has been submitted that the impugned order does not specify the period of deputation. Stop. Until and unless a specific period is mentioned, it will be deemed that the teachers would be under deputation for their entire period, service period. Stop. Next. Prayer has been made to relieve the petitioners from the duties as may be assigned by the electoral registration officer. Paragraph. Learned Counsel representing the Election Commission of India refers to the impugned order and submits that the said order has been passed in consultation with the concerned officer. Stop. The same is not an unilateral order. Stop. Next.
Not the concerned officer, not the authority. If you lordship will
Acha, officer is jagah the school authority. Acha. It has been submitted that
education institution.
guidelines have been published by the Election Commission of India, specifically mentioning that the teachers shall be drafted minimally as booth level officers. Stop. Where necessary, comma, teachers should be drafted work during holidays and during non-teaching hours and non-teaching days, so as to avoid any loss of academic work. Stop. No teacher of a single teacher's school shall be deployed for the purpose. Stop. The activities of the booth level officers should be planned in such a way that it does not affect the work of their parent department. Paragraph. It has been submitted that that work is yet to be assigned to the officers, and the work will certainly be assigned keeping in mind the guidelines laid down by the Election Commission of India. Paragraph. Upon hearing the submission made on
It is represented, but I am adopting the arguments of the Mr.
learned advocate representing the state adopts the submission advanced by the Election Commission of India. You are also there? Union of India or same kore deben, state and Union of India, both. Upon hearing the submission made on behalf of the parties and on perusal of the documents placed before this court, it appears that though order has been passed by the electoral registration officers appointing the petitioners as booth level officers, but specific work the booth level officers are required to perform is yet to be assigned. Stop. As on date, it cannot be ascertained as to the nature of work that will be assigned upon the concerned officer. Stop. The writ petition appears to have been filed apprehending that the teachers may be appointed whole time, keeping in mind the nature of work that they may be required to perform. Stop. Paragraph. As it appears that the individual teachers have not been assigned any duty, accordingly, the instant writ petition is disposed of with the observation that the duties that will be assigned to the officers shall be strictly in terms of the comprehensive instruction regarding booth level officers as published by the Election Commission of India on 4th October 2022. Stop. The Honorable Supreme Court has specifically laid down in St. Mary's School within brackets Supra that the teachers may be required to work only on holidays, non-teaching days and non-teaching hours. the Election Commission of India and any other officer assigning work upon the petitioners shall strictly act in terms of the aforesaid instruction published by the Election Commission of India. Writ petition stands disposed. Affidavit of service is taken on record, and the receipt showing deposit of deficit court fees be also retained with the records.
Only one humble submission. Not suppose not on a case-to-case basis. There may be certain schools where there is no student at all. So
As and
it's
when
possible.
matters come,
As and when this will be coming flooding the court.
this is the reason I inquired how many students are there in the school.
It has been done
What
in
is the
consultation with-
working order, the working hours, and then only.
Say the head of the institution may be in a position to spare the gentleman for the part of the day.
Maybe.
Head of the institution has been called for also. The
And
first
he
in first
has-
petitioner head of the institution.
He has accepted this,
Accepted this means, Malad?
the proposal of putting the teachers in deputation.
No, Malad, he has been deputed. Head teacher has been deputed.
I have seen a list of head teachers. That is
Yes, they have
annexed
been
also.
deputed. All they have been deputed.
Only on holidays and for the time being.
Yes. Call the next one, please.
I cannot find.
Should I appear for the petitioner? I appear for the private respondent. The tender matter not where the private respondent is probably
Private respondent is?
probably being accommodated despite not non-fulfillment of the mandatory conditions. So
All
the
right.
apparent not available.
By which authority?
But this is for upgradation of road by Birbhum.
All right. The Panchayat and Rural Development, you are there.
Panchayat and Rural Development.
All right. Yes.
It's at Birbhum and not the. It's a stretch of 7 kilometers road which is sought to be upgraded.
Hmm.
Now, please come to note the disqualification clause at page 37. Now, this would mean not as mandatory term of the tender. Not this has to be done because otherwise it would not have featured. under
Which
the-
portion?
not
Page
clause 4.7 at 37.
4.7 at 37. Disqualified.
Even though the bidders meet the above eligibility criteria, they are subject to be disqualified if they have. So, not these have to be treated as mandatory clauses. Made misleading or false representations in the forms, statements, affidavits, and attachments submitted in proof of the qualification requirements, or record of poor performance such as abandoning the works, not properly completing the contract, inordinate delays in completion, litigation history or financial failures, or participated in the previous bidding for the same work and had quoted unreasonably high or low bid prices and could not furnish rational justification for it to the employer. Then not 5 is something else. Now please have a look at not page 52.
Yes.
Now, this is appendix to ITB. This is one of the essential features of the contract tender. The employer should fill out this appendix to ITB before issuing the bidding documents. The insertion should correspond to the information provided in the invitation for bids, instructions to bidders. The employer is so and so, the work is so and so, identification number. Please come to 4.4BI. The key equipments for road works and field testing laboratory road works are for road works, not these. So one has to declare how many quantity or what type of equipment is to be utilized for the purpose of this work with the valuation thereof. But it goes on like this. Not please turn over to 53. Category B for works with WMM and followed by BM and so and so. But the nature of the articles to be used or the equipments to be used. It goes on till 56.
Yes.
Now please come to 15.1. The bid validity date is 2/9/2025, and down below 22.1 and 22.6. The date and time for opening of the bids are: technical qualification part of bid is 3rd of June 2025, and technical financial part of bid is so and so. Not it's a two-tier bid. One who qualifies on technical terms, he moves on to the technical financial part of the bid. Now.
Yes.
This gentleman or not the private respondent, not he has not submitted not this entire list from pages 52 to 56. So this is non-disclosure. In terms of technicality, apropos the bid document. But please now come to page 117 and 111.
Representation.
First 111.
Yes.
He has been found to be technically qualified despite this sample certificate not having been given with a date. But this is the format.
Sample
And his document is at page 13. His document is at page 124. This is the sample provided by the employer, and 124 is the document which he has furnished.
So bank certificate at 124 is not in line with 111.
Is not in line with 111. Number 2, he has skipped over the entire essence. The bottom on the note at 111. Certificate should be on the letterhead of the bank, and phone, fax, and email address should be written clearly and not older than 3 months.
So the date is important.
Yes. Now please come to 117. Note what he has lacked, and this has been pointed out to the tendering authority.
117.
117. Note these are on the basis of the information available on the website.
All documents of all the participants are uploaded. It can be viewed. 117.
Please see the first paragraph, the last line. The irregularities which prompted us to write this objection are as follows.
117. The irregularities, yes.
In spite of having ongoing work of the WBSR DA Birbhum division, the bidder not showed his ongoing work in assessed available bid capacity. 2. The bidder has submitted bid capacity calculation sheet, but the calculation sheet not as per the SBT clause 4.6. That was that page 52.
All right.
The bidder has not submitted his updated trade license. This is mandatory for tender submission. The bidder has not submitted updated GST return. This is mandatory for the tender submission. As per the SBD, that's the document, bank certificate should not be older than 3 months, but the bidder has submitted bank certificate.
Is there any scope for submission of objection pre-bid meeting or anything where objections are taken into consideration?
Authorities have uploaded him and found him to be a technically qualified bidder. That's at page 132.
Despite all the irregularities pointed out by you. 132.
Have to be treated as essential conditions of the bid.
All right.
Can't be directory.
All right.
Has not submitted EPF and DSI challan. This will all befall on the government at the end of the day. The bidder has not submitted its turnover certificate. The bidder has not submitted its payment certificate in support of turnover. Also, the bidder has not submitted particular payment certificate in support of its submitted credential. The bidder has not submitted documents against excavator cum loader.
All right. So you are aggrieved by the declaration of the private respondent as technically qualified candidate.
This has been downloaded from the website. This is what he has an expired trade license. And this is page 123. But please reconcile this with page 123. Just 31st March 2025 expired. But it expires.
Clarification दीजिए that 10th April document has.
But he is bidding after expiry of the validity period of trade license.
And are you sure it has not been renewed?
This is what has been uploaded.
This is what is
what has been uploaded.
All right.
Lord, the topic kindly takes Lord the NIT. Lord, at page 26.
Yes.
Lord, kindly sees the nature of work. Lord.
Yes.
Lord, construction and upgradation of road, Lord, it's an infrastructure project, Lord. Lord, upgradation of road from such and such to such and such, Lord, construction of road, and Supreme Court says your Lordship knows better than me, Lord, it's an infrastructure project. And Lord, financial bid opened, Lord, on 31st July 2025.
Financial bid or technical bid?
financial bid. Milord, both the Milord private respondent and reputation qualified in the Milord technical bid. Thereafter, Milord financial bid open, and Milord the private respondent tender evaluation committee found private respondent has quoted Milord 5% Milord
Less price
less
than
price
what
than
the
the amount put to tender. And Milord, yes, it has been uploaded Milord, and Milord the petitioner has quoted 3% point 3%.
all right, maybe price wise.
Grievances he has raised, Milord.
Hmm.
Milord, point wise, it has been Milord redressed, and Milord, we didn't find any unsustainable Milord complaint.
The trade license.
Yes, that has been up. We have verified it. He has given us a Milord a trade license, which is Milord dated cover
10th April
10th April 2025. 10th
And
April,
then
that
why
has been
is
uploaded.
the lapsed trade license
So that is
uploaded?
Milord, they have furnished a fresh trade license.
When? After the you declare the private
No,
respondent
prior
as
to that,
successful?
prior to that. Soon
Why
after,
has the uploading not
soon
been
after,
done?
Milord, soon after getting the complaint, we Milord called the Milord the L1 bidder. Milord subsequently Milord he became the L1 bidder. We have called him, and Milord point wise the representation they have sent Milord point wise we have clarified and verified. We found there is no answer.
No, but then
Milord, I have for your lordship assistance. Milord, I have prepared a point wise Milord.
all right, wait. Thing is the bank certificate.
Yes, bank certificate. He is up to date. Milord, all the documents are
The date is mentioned.
Yes.
So why have you not uploaded all documents? How will the other bidders get to know?
Milord, there are two bidders.
Date not mentioned, but bank certificate was verified. Bank certificate was verified.
Milord, bank certificate is verified from the bank itself. After getting his complaint, bank certificate is verified.
All right, I'll hear you. But then I want to hear from the authority as to what steps you have taken for.
Milord, all the grievances he has raised in his Milord representation that has been verified and checked, and we found everything
Which
is
page
not
is your objection that you raised?
Page 117, Milord. Milord, for your lordship's kind Milord perusal, Milord, I have prepared one Milord assistance, Milord, I have prepared one Milord redressal, point wise redressal.
All right.
And
Where is it?
Yes.
All right.
Yes. Yes.
Because there are quite a few objections that have been raised. 16 I can see.
Not all the 16 have been dealt with, Milord.
All the 16 dealt with?
All the 16.
You file a report as to how you redress the grievances.
Yes, but we should file it out. In the meantime, Milord, infrastructure job, Milord, construction road, Milord, there should not be any interim order. That is my humble prayer.
All right.
Your lordship knows, Milord, the
Work order has not been issued till now.
Work order not been issued. Milord, may I cite one judgment? Your lordship knows this.
No citing judgments. The this is we are in the monsoon season. Are you issuing work order during the monsoon?
Yes. Milord, it's
what? Yes. Are you all issuing work order or not?
We'll be issuing.
Kindly state that.
Milord, kindly.
You'll be issuing work order during the monsoon season so that everything the contractor does goes down to the drains.
No, Milord,
you are not issuing work order. At least for 1 week you are not issuing work order.
No, lordship.
Today is Monday.
Yes.
By Friday you circulate.
Yes.
How you have redressed the 16 or 18 points that are there.
Yes.
16 points. All right. Thereafter, and you are already here, you say you have complied with everything that is required because the state is supporting you. So nothing from your side will be required. The state will come up and say.
May I say to one judgment? Yes.
No judgment.
No,
No, I'm not granting any interim order. You say that you are not going to issue work order for a week. I'll post it next week itself. The matter relates to a tender process floated by the superintending engineer, Mednipur Circle. Panchayats and Rural Development Department.
That on instruction I am submitting.
For construction and maintenance of works under PMGSY-Roman 3, batch number 1 of 2024-25, page 22. Stop. The petitioner and the private respondent both submitted their bid in response to the same. Stop. The private respondent has been found to be successful. Stop. The petitioner raises various objections with regard to the documents of the private respondent, which have been uploaded in the portal by the authority. Stop. Pages 117 and 118 of the writ petition contains a list of objections against the technical evaluation of the bid. Stop. It has been submitted that several mandatory provisions have been infringed. Stop. There has been gross suppression of facts and non-disclosure of documents by the private respondent. Stop. Prayer has been made to stay any further steps to be taken in terms of the tender notice. Stop. Learned advocate representing the private respondent submits that all documents as required under the tender notice have been submitted before the authority. Stop. Learned advocate representing the state respondent submits upon instruction that the objections raised by the petitioner was duly considered and all relevant documents from the private respondent are available on record. Stop. Paragraph. The learned advocate for the state respondents have already been forwarded a detailed report by the
Respondent number
superintending engineer dated 3rd August 2025.
The complaint
Stop.
found unsustainable. Your lordship kindly record my statement.
Complaint
The
from?
grievance they have raised found without unsustainable. How it can be?
Acha. The according to the authority, the grievances raised by the grievances/objections raised by the petitioner have been found to be unsustainable. Paragraph. Learned advocate represent no. The superintending engineer is directed to file a very short report disclosing the manner as to how the grievances/objections raised by the petitioner have been dealt with by the authority. Stop. The the affidavit shall be prepared and circulated by this Friday 8th.
Monday, your lordship.
আচ্ছা ঠিক আছে 10-11 তারিখ release the matter for further consideration on 18th. Stop. It will be open for the petitioner to file objection to the same prior to the adjourned date. Stop. Who is the officer standing behind you addressing?
Assistant engineer.
Assistant engineer.
Achha. The assistant engineer of the department is personally present in court. Stop. It has been submitted that since the monsoon season is ongoing, the work order may not be issued immediately. Stop. Keeping this in mind, hearing of the writ petition is adjourned till 18th.
18th, my lord.
You can take this back.
Yes.
Affidavit of service is taken on record. This copy also to be taken back. Very short, only how you have dealt with the objection. Nothing more. Oh, arekta jinish. The department is directed to immediately upload all further documents of the parties so that all the parties so that transparency in the tender process is strictly maintained.
Grateful.
Item number 6.
Yes.
Your Lordship, the affidavit of service of the can. And I have filed one supplementary affidavit also, Your Lordship. It may be taken on record. I have served to all the parties.
Yes.
It or to the other. Affidavit of service. It affidavit. Review, Your Lordship, I had prayed for the non-transfer of the proceedings of my junior as well as myself because the cause of action which arose during the course of the proceeding of my client.
When
Your
is the
Lordship,
matter before the division bench pending?
It's on 6th of this month, Your Lordship.
6th.
Day after
All right.
yesterday.
So I'll adjourn hearing till 11th.
Yes,
Next
Your Lordship.
Monday, following Monday.
My lord, in respect of the review application, it is better to adjourn, my lord. But in respect of all other applications which has been listed, that can be heard out. Well. There are 3 applications as I know, my lord. And I think 2 applications were filed on my behalf, on behalf of the West Bengal Bar Council.
Can 1 and can 2?
Yes, my lord. One in relation to review application, and since that was delayed of 60 days, an application seeking for condonation was also filed. These 2 applications are pending on my behalf.
All right.
And she had filed another application, my lord, very recently seeking for a direction for not transferring the disciplinary proceedings.
That is not in the list possibly. Or is it there? Is it there?
Yes, Your Lordship.
Can 1
was filed earlier during December, Your Lordship. December
Can 2?
2024. Can 2 has been filed recently, Your Lordship.
Your can?
No,
Your
no.
can is can 1.
No, can 1.
Can 1 of 2025. Her can is can 1 of 2024.
Can 1 with review application he is referring.
A list देखो तो can 1 of 25 तो नहीं.
With review application. At 1 of 25 with
1
review
of
application.
25 is in connection with the review.
Review, yes, Your Lordship. They have filed. Review is
Section 5.
Section 5.
Okay, section 5 with connection with the review.
Your Lordship, it may be heard on the next Monday because I am having 3 matters in court number 4 within some time, Your Lordship. It is fixed.
The entire thing you want to be adjourned. Well, if he petitioner in person appears and it's
Your
up
Lordship,
to you.
can 2 may be heard, Your Lordship, today. I have no.
My pleasure to find her occupied in other matters also.
Yes,
Can
yes.
may be heard, Your Lordship. I have no.
No, it should be.
Can
Certainly.
my clients are suffering, Your Lordship. Short pass over maybe.
An appeal from the order passed in the writ petition is pending consideration before the Honorable Division Bench and is reported to be taken up for consideration on 6th August 2025. Stuff in view of such submission, hearing of this matter stands adjourned till 11th.
Deeply obliged.
My lord, I'm appearing with Mr. Amal Mukherjee, my senior, for State Bar Council. My lord.
Please finish it off before the division bench, my earnest request.
My lord, as a matter of fact, I have tried by level base to get the matter listed before the Honorable Division Bench. Since the bench is not
now listing is over, disposal is to be done. Please. Next.
Grateful, my lord. Grateful, my lord.
Item number 7. Number 7.
কি আছে দেখি দেখি ডাকা হয়েছিল আগে আচ্ছা none appears on behalf of the petitioner at the time of call. No accommodation. Dismissed.
Acho. My lord, I am for the petition.
I am for the respondent, my lord.
My lord, this is a transfer petition, transfer brief. My lord, in this case, I have find out that they have filed a report. They have filed a report in the form of affidavit. I am an inquest payer is there. Because there is annexure P1, the letter has been issued by the AGM Durgapur FCI to the General Manager FCI Royal Seat Calcutta. But on the basis of that application, that letter, deputation may be disposed of considering the pair A, page 12.
My lord, may I just give a brief?
1 minute. Where is your
Here, my lord, page 12, pair A.
what they have filed an
They-
affidavit? You
Yes,
said
my lord, they are seeking
They have
release of.
filed a- They have filed a, sorry, they have filed a report.
they have filed a report.
My lawyer who is in a brief has prayed for my evident reply. But my submission is this, matter is 23 and my.
It can be disposed of.
Yes.
Yes, relying upon what?
But relying upon annexure P2, P1, P1, annexure P1, page 16.
P1 in the
Writ petition, my lord.
P1 in the writ petition.
Yes, page 16, 16.
Page 16.
Because matter
Release, you want release of security deposit?
Yes.
Why is it being withheld? Reason for withholding the same?
I was there as a handling transport contractor from Asansol Railway side to FST.
Right. Yes.
After having the tender, we
Right.
succeeded in tender, we have to deposit the security deposit. We have deposited the security deposit.
Now tender is over.
Tender is over.
Why is it being withheld? There must be some reason as for withholding the money.
That is the reason mala paying to that. Mala they give the opportunity hearing and pass the order.
No, in the report must it
Yes,
must
my
have
lord,
been
the
stated.
report, the reason of withheld, my lord, is report
Page.
is page 23, my lord.
23.
Here, my lord, we have explained the recovery is done from our end, my lord. So, for the
Alright.
tender document is concerned, my lord, we are stipulated to get the deduction, recoveries and set off, my lord.
Payable. Security deposit, how much is the security?
My lord,
20.
33 lakhs 46,000 was the total security amount. Out of two, my lord.
As per terms, rupees 24 lakhs 53,600.
My lord, there were two contracts. My learned friend perhaps is
Yes,
not
yes,
properly briefed. There are two contracts. my lord.
My lord.
1 minute. 33 was he paid.
My lord, 33, 46 was deposited
Yes.
with us.
Right.
My lord, we are entitled to get certain recovery that we have done. And
Yes.
accordingly, if my lord kindly turns to the next page, my lord, paragraph number 5. At present, a
Subject to
sum of rupees 24 lakhs 46,898 is payable to the writ petitioner, subject to production of NDC, means non-due certificate from the assigned.
Employee State
Yes, my lord.
Insurance Corporation
They
Authority.
did not comply with it, my lord. Accordingly, my lord, in the meanwhile, we have made. Kindly allow me, my lord, friend. In the meanwhile, my lord, we have made the payment and we have
How
informed
much?
also. That is 4 lakhs and odd, my lord. And we have
4 lakh out of 24, 20,000 was the due of the Employee State Insurance Corporation.
No, my lord, that was the due to be payable to him, including, my lord, the amount payable to the ESI authority.
That means you've paid only for
4 lakhs,
and
yes.
20 was due
Yes,
to
yes, yes, yes. That amount is, my lord, is payable to them. I am ready to make the payment, my lord, if the my lord is so direct.
How much is payable to them?
My lord, 20 lakh 37,938. After paying the, my lord, the statutory amount to the ESI authorities.
What is the statutory amount?
My lord, that amount we have, my lord, informed to the writ petitioner, my lord, that the amount we have made the payment 4 lakhs. The amount paid us, my lord, 4 lakhs 8,960, my lord, total. On two accounts, my lord, we have made the payment. If we made the, yes, my lord, at the very end, my lord, it is mentioned 4 lakhs 8,960.
So from 24,
Yes.
4689 minus
Yes,
this is to be done.
Yes,
So
my lord.
whatever is balance paid.
Yes, my lord, that 20 lakh 37,938.
Where is the figure?
My lord, that is not there, my lord. It is
It's not there. You
no.
calculated it.
Yeah, I have calculated it.
What is the figure?
My lord, 20 lakh 37,938.
My lord, may submit to Lordship as an instruct my client right now because transfer brief. There is a bank guarantee 59 lakhs and after 7.
That is not part of the writ petition, my lord. I do not know on which basis my learned friend is submitting. That is not part of the.
Your figure that you showed was 24 lakh.
24 lakhs.
Then if you got something else separate.
That's the reason, my lord, I am saying that they must give an opportunity of hearing so that we can place that. Because I have given 59 lakhs and 7 lakhs bank guarantee. Apart from 24 lakhs.
That is not
And
part
my
of the writ
learned friend-
petition, my lord. That is not
Uh,
part of the writ
please come.
petition.
Right
Please
now-
come. The
My learned
instant
friend says-
petition was filed by the petitioner seeking release of security deposit. which the petitioner submitted at the time of entering into a contract with the Food Corporation of India to the tune of rupees 24,53,600. And also for payment of ad hoc. What is this ad hoc? Page 13, prayer 892410.
Well, there are two contracts. One was 24 lakhs, another ad hoc contract for 8 lakhs. The total, my lord, the
And ad hoc contract. Rupees 8,92,410. Stop. According to the FCI, a sum of rupees 4,08,960, which was due from the petitioner on account of the payment to the employees' state insurance corporation, have been released in favor of the said authority.
My lord, may I submit also one thing,
Stop.
subject to my lord kind permission?
A sum of rupees 20,37,938 is payable in favor of the petitioner. Stop. The Food Corporation of India,
10 years pending.
Food Corporation of India is agreeable to refund the balance amount.
Not with interest, my lord. 10 years.
my lord, they are not entitled to get interest. So far, the tender stipulations are concerned, my lord.
That is total
Balance amount.
My
Stop.
lord, that is
Next.
contractually, my lord, they have waived their right
The
to claim
petitioner
interest.
submits that there are other dues payable to the petitioner. Stop. It appears that as regards the other dues, the same do not form part of the writ petition. Accordingly, no order can be passed in respect of the same. Stop. The instant writ petition is disposed of by directing the Food Corporation of India to refund the amount that is due and payable to the petitioner, strictly in accordance with law and the terms and conditions of the tender.
My lord, kindly consider of this, my lord, 10 years. my
At
lord,
the earliest,
taken the amount.
but
in the-
positively within a period of 4 weeks from the date of communication of this order, subject to compliance of all statutory formalities.
Deeply obliged.
My lord, may I submit to also, my lord, there is no tension of point in the tender, but they have taken custody of my entire amount last 10 years.
Yes, but if it
But
was
then-
payable without any
My lord,
interest, then
kindly
what can
consider
be
the
done?
interest. Then kindly consider the interest.
If it is not payable with the interest, then what can be done?
That they have issued that.
No, I won't consider anything. You make any
Single document, my lord.
you make submission before the authority.
Item number 9.
Dismissed. Record your appearance.
For the respondent bank.
Appear for.
Last location, it was dismissed for default.
It was. Niki?
Junior says that there was an application for restoration, but no service was done on it.
Anyway, it is dismissed once again.
Thoughts?
Record your appearance.
Item number 10.
I'm for the petitioner. This is my relating to releasing of fund under housing scheme. These petitioners earlier came before this honorable court, and as per direction of the honorable court, the district magistrate taken a hearing. Page 30.
Page?
Page 30.
Yes.
Page 30, my lord. The petitioner is eligible, considering the field level report submitted by the BDO concerned and subdivision. The following petitioners have mud and thatch house who are eligible to get the benefit Gitanjali scheme. Now the petitioner's name has been appeared. Now next page.
Where is the deficit court fees? Did you pay it?
My lord,
There is a direction in 2023. More than 2 years have passed.
my lord, deficit could be, I will pay, my lord. Your lordship can you-
There is a direction for
Yes, my lord.
payment.
Perhaps,
Why did you not pay it?
perhaps, my lord, this is my fault. I could not contact with you. My lord, your lordship can
By 18th April 23, you were supposed to
Yes,
pay.
therefore, my matter has not been appeared. My
So what? The time was fixed by the court.
yes. देखिए, blue pen देखिए.
Acha, none appears for the state. Stop.
Anil, मैंने
The deficit court fees as directed to be paid. Video order dated 17th April 2023
other petitioner
has not been,
other petitioner names have been expunged.
the names may be expunged. Acha. তাহলে একটা কাজ করুন। For the state বললাম তো? There was a direction for payment of deficit court fees. Video order dated such and such. Learned advocate for the petitioner submits that the writ petition may be restricted only in respect of the petitioner number 1. And the names of the and the other petitioners may be expunged from the writ petition. Stop. In view of the aforesaid submission, the order passed in the instant writ petition shall only be effective for the petitioner number 1. Stop. The writ petition shall be deemed to have been dismissed in respect of the other petitioners. ঠিক আছে? The petitioner seeks payment in terms of the housing scheme. Show me, I have passed similar orders.
Yeah, your lordship did not pass, my lord. The order passed by my lord justice.
No, this bench has also passed order. Last week
Your
also.
lordship can pass that order.
আচ্ছা, আর কি বললাম?
Petitioner seeks payment in terms of the housing.
Housing scheme stuff. Where is your prayer?
Right. As per my lord, earlier direction passed by this honorable court, the page 30, the district magistrate heard the petitioner and passed the following orders. Page
Acha,
30
yes,
now.
you are directed to include the names of the mentioned beneficiaries.
Who are eligible to get
The next
benefit of the
if they
petitioner
do not get
benefit thereafter, my lord.
Yes.
Page 31.
And is your name appearing in this page 30 and 31?
Yes, yes.
Where?
Then,
Bishwadev Mondol. This is in respect of Satyajit Mondol and others.
Serial number 15, 15.
Serial number 15, Bishwadev Mondol.
Yes.
ঠিক আছে। এবার লিখুন, the petitioner has been found to be eligible. Include the name. Now, ওটা কেটে দিন। লিখুন, the district magistrate Malda, video order dated 22nd September 2016, directed the subdivisional officer within bracket Shodor Malda and the block division development officer, Manikchok Malda, to include the name of the petitioner as beneficiary under the Gitanjali EWS housing scheme.
Now Gitanjali scheme is no more, my lord. Now Banglar Badi scheme, my lord, under the same style.
Stop paragraph. It has been submitted that the Gitanjali housing scheme is no longer available, and the petitioner ought to be given benefit under the
Banglar
Badi scheme. ঠিক আছে, paragraph. As it appears that the petitioner was found eligible to obtain benefit under the economically weaker section of the housing scheme and the subject scheme in which the petitioner was directed to be enlisted is no longer available. Accordingly, the benefit of the housing scheme for the economically weaker section of the society shall be extended to the petitioner in respect of any other available scheme of the same nature. Same na kore similar nature. Stop. The block development officer Manikchak. No, the block development rage, the subdivisional officer within bracket Shodor Malda and the block development officer Manikchak Malda are directed to take necessary steps in this regard and ensure that the petitioner actually receives the benefits without any further delay. Writ petition disposed.
May I only one instead of BTO Manikchak, if your lordship kindly give direction to the district magistrate, because district magistrate is
DM has directed the BDO to do
Yes,
it.
yes.
District magistrate cannot do it independently. He has enlisted you, that is all.
Great.
Next.
Much obliged.
Item number 11. I feel for the bank. Okay, ma'am.
I am for the petitioner, lordship. Need to file a reply, lordship. Bank has filed the opposition, lordship.
It was in 23.
Direction for payment of 6 lakhs.
Yes.
They have not paid.
All right. What has happened to the property?
And then a surfacey proceeding is going on where reply has been filed. Pleadings are complete.
Before the Debts Recovery Tribunal?
Lordship, we have paid the amount, lordship.
All right. Please come.
2023, not a single.
It appears from the submission made on behalf of the parties that
We have paid, lordship.
the issue in consideration is currently pending consideration before the Debts Recovery Tribunal. Stop. The in view of the above, the court is not inclined to keep the writ petition pending any further. Stop.
Lordship,
it will be open for the
Lordship, we have
parties.
already paid the amount, lordship. Kindly keep it for one week. Adjournment may be given, so I can show that.
Yes.
I can show the documents that I have already paid, but they are not taking the further amount, lordship. They are proceeding with the.
Yes, your tribunal application is pending, so you may call prayer before the tribunal.
As per direction of the Honorable High Court, lordship, we have paid. The first time when we went to pay the money, that time due to the link problem, lordship, that was not done. Afterwards, we have paid, but as within that time, specified time, we have not paid. They are not considering that is a settled amount.
What can be done?
Lordship,
There was a date mentioned in the court's order.
No, lordship, but that time we tried to pay.
So you make all submissions before the tribunal. No use.
Lordship, kindly keep.
What is the use of keeping it pending for a week?
The matter came up suddenly, lordship. It was in the list in the. But suddenly it came up as item number 11, lordship.
Yes.
I'm ready with I have contacted my client, lordship. Kindly give 1 week accommodation so I can take instruction after 1 week. Your lordship may dismiss.
কি বললাম আচ্ছা না ওই জায়গাটা কেটে দিন বললাম না ইট ইজ পেন্ডিং কনসিডারেশন বিফোর দি ট্রাইব্যুনাল না ওটা হবে না তার আগেরটা
The issue in consideration is currently pending consideration before the Debt Recovery
Tribunal. The court, ওটা কেটে দিন. The court, wide order dated 2nd March 2023, directed the petitioner to pay rupees 6 lakh by 24th March 2023. Stop. Admittedly, the said amount could not be paid within the time stipulated by the court. Stop. The learned advocate for the petitioner's claim that money was deposited. Now, money could not be deposited within the time fixed due to link issues of the bank. Stop. The money has been paid immediately thereafter. Stop. prayer has been made by the learned advocate representing the petitioner to take further instruction from her client's stuff. In view of such submission, list the matter on next Monday, 11th. You record your appearance, please.
Lordship, instead of 11, can it be on 12th?
All right, 12th.
My lord, both the matter, I am for the petitioner.
Yes.
My lord. My lord, I am appearing for the respondent IOCL, my lord, in item number 12. My lord, I am taking 2 weeks time to file my opposition, my lord.
23 matter, now opposition you want to file.
My lord,
Why? What were you doing for so long? 23 direction was given for filing opposition and now you extend it. Sorry, sir, I cannot extend the time. What is it? What is your prayer?
my lord, here in this matter, I am challenging, my lord, for tender for equality and tranquility in the tender process. What happened is, I am belonging to scheduled class. Indian Oil Corporation issues the tender notice for transportation of the bitumen and crude oil and others. For tender in the previous year, my lord, when Indian Oil issued the tender for scheduled class type, they gave the concession. This year, 2023, they did not give concession. We made a representation. My lord, your lordship kindly come to earlier year's order that I came before this one. Your lordship kindly come to page, my lord, your lordship, page 108, page 108, annexer P3. For the year, annexer P3, page 104.
This communication was considered. This is what the court has recorded in the order. December 14th, 2022 has been considered and replied by a communication dated 5th of January 23. Then what remains?
My lord, that challenging, my lord, that we have filed a supplementary affidavit. Your lordship kindly come to my supplementary affidavit.
Yes.
There, my lord, they did not consider at all. Because in the supplementary affidavit, my lord, your lordship kindly come to next item number 13, that I have filed the supplementary affidavit. When they produce the letter, my lord, your lordship kindly come.
Let me see item 13.
13, item 13.
I am appearing on behalf of. All right, supplementary is there.
My lord, your lordship.
So far as maintainability, I will be that
Yes.
question was
Kept open.
my lord.
Yes.
Was not the applicant, my lord. And the earlier petition, my lord, which was initiated by the petitioner himself in this, it was categorically provided, which forms annexure to this petition, Pratibha Das's matter, my lord, at page 87. If your lordship comes, my lord, the Honorable Court Coordinate Bench observed Pratibha Das's matter at page 87, my lord, that the perusal of the security deposit clause in the present tender process reveals that only successful tenderers shall be required to furnish said security deposit within 15 days of issuance of LOI. As such, it is clear that the issue raised by Mr. Chatterjee in the present petition can be considered only after the petitioner emerges to be successful in the same tender process. Now, the read petitioner himself never applied for the tender.
Himself means?
He didn't apply for the tender process, my lord. Now, this is a transport agreement, my lord. He has to offer tracks, my lord. Her contention is this, that initially, prior to this tender process, IOCL used to charge 2 lakhs per contract, my lord. However, from
at the schedule type, we make the concession.
Seema Das and Pratibha Das.
So far as Pratibha Das is concerned, my lord, I am appearing, my lord. Pratibha Das is writ petition, my lord.
Yes.
In earlier occasion, it was this contention that a single tank trucks, an amount of 2 lakhs was supposed to be deposited by the tenderer after getting successful, not tenderer, the incumbent after getting successful. From this tender, the IOCL has advertised the advertisement for tank truck, that for each tank truck, they will be entitled, the applicant will be entitled for 50,000 per tank truck, my lord. So far as the SC/ST. And so far as general applicant is concerned, that is 1 lakh, my lord. Her contention is this, that the tender terms should be modified, my lord. The tender process was initiated during the year 2022, and from 23, my lord, that has started, my lord. 26 SC/ST candidates have already applied and got their tender process, their tank trucks offered and accepted by IOCL as successful candidates, my lord. Now, in view of the fact that she didn't apply for the offering the tank truck in this process, my lord.
Pratibha.
Yes, my lord. Now, this repetition itself is not maintainable as per the order of this court, my lord, which was filed.
All right.
My lord, your lordship kindly come earlier at tender, page 81, page 81.
In Pratibha's matter,
Pratibha's matter,
81.
page 81. Your lordship kindly come.
Yes.
Have you got B, security deposit?
Yes.
My lord. Yes. My lord, may I read? Successful tenderer shall be required with furnished within 15 days, such and such. A.
1 minute. 1 minute. Successful tenderer. Did you participate in the tender process?
Yes. That's what I was participating, my lord. I attended.
Participated.
My lord. Then, my lord.
Oh, 1 minute. You say you participated.
My lord, your lordship, kindly allow me.
Oh, tell me whether you participated or not, and if there is any document to show participation, please show.
Yeah.
My lord, Pratibha.
My lord, your lordship, kindly come to next year 86 page judgment of this court.
Not judgment. You show me that you participated in the tender.
My lord, he has not participated.
1 minute.
This year I have not participated. 2000.
Not this year.
Earlier, my lord, earlier we have participated, my lord, your lordship. According to tender process, Supreme ST candidate, they have to deposit 50,000. My lord, because we came to this court.
The very first thing that you read out is a successful tenderer is required to deposit something. If you participate in the tender process and you become successful, then only the question of depositing security deposit will arise.
No, my lord, your lordship kindly cut that, because from the very terms of the contract which is there, my lord, they shall be before filing the tender, they have to, my lord, your lordship kindly come. Yes.
Filing the tender, they
Yes,
have to deposit the security deposit.
Yes.
Why will they?
There is no Your lordship,
Honest money may be something different. Security money is something different.
cannot be, my lord, nowhere.
How can it be?
Now, your lordship kindly allow me. Just 1 minute, my lord. Your lordship kindly come to that year in 2023, that terms and conditions, my lord. Your lordship kindly.
The authority says they did not.
This year we have not participated.
My lord?
Initially, you did not participate.
No, at that year, 2020-21, we have participated. But this year we have not participated, because this year tender clause has been withdrawn. This clause has been withdrawn. We have challenged this tender process, my lord, 2003-4. My lord, your lordship kindly come.
The matter relates to a tender process floated by IOCL in the year 2022.
23.
Yes, 22-23.
22-23.
23, my lord.
The petitioner is aggrieved. The petitioner alleges that the authority sought for security deposit.
No, my lord, this year no security deposit, nothing. This year tender process has been called for. Your lordship kindly come to this year tender process. I'm kindly come, your lordship.
22-23. We are considered
22-23, my lord. No, nothing is there. Because your lordship kindly come to only for.
What nothing is there? You participated in 22-23, or what is the challenge? Which year tender?
22-23, we are challenging the tender process, my lord, but because of the equality and tranquility in the tender process. Because earlier year for scheduled tribes, there is a clause to deposit, my lord, 50%, 50,000 annual. But this year they withdrew it. They did not allow scheduled tribe, no concession. So that's why we have filed an application, because this authority concept that because earlier year you gave the concession to the scheduled tribe, that but this year they have withdraw the concession. So we make a representation. According to representation, they
Now the tender process is over.
now tender process.
What remains in the writ petition?
My lord, I can challenge, my lord, if there is a, my lord,
You challenge afresh. After
lord,
filing of the writ petition, the tender process has already been finalized. What remains in the writ petition?
Started from 1/1/23.
tender
And now it has been finalized.
Yes, my
It
lord.
has been
Whenever
finalized,
it's
work
running
order
for
has
the
been.
Work order is. Sir,
It's running for the last 2 years, my lord.
And my lord, we can, my lord, if there is, my lord, your lordship kindly come. This is the, I have the right, my lord, tender, I have the right to challenge that, my lord.
petitioner alleges that the
If it is
provision for
the tender process, I have the right to challenge, my lord.
provision for reduction
For scheduled type.
provision for depositing a reduced rate of security deposit has been withdrawn by the authority. Stop.
For
Paragraph.
scheduled tribe, my lord.
For the scheduled caste and scheduled tribe candidates.
Has been withdrawn.
Stop. The learned advocate representing the IOCL submits that the tender process is long over and work order had also been issued in favor of the successful tenderers. Stop. The petitioner did not participate in the tender process at all. Stop. After hearing the parties, it appears that that it is too late in the day to interfere with the tender process, where rights of third parties have accrued and crystallized. Stop. The work order was issued nearly 2 years back. Stop. At this stage, it will be highly improper to interfere in the same. In view of the above, the writ petition fails and is hereby dismissed.
My lord, only for one judgment I have received that I have the right, my lord. If there is the equality and fair treatment, if that is not, so I have to, this Supreme Court case will test it. So I have the right.
Your
Both the petitions same, my lord.
both the petitions same.
Same.
Shima Das also did not participate.
No. We did not participate, but we challenging the tender process.
দুটোই একসাথে হবে with দিয়ে করে দিন
Because of this clause, we have not participated.
আচ্ছা learned advocate for the petitioners, show me the judgment.
My lord, this is paragraph 40.
Refers to the judgment delivered by the Honorable Supreme Court
Para 17.
in the matter of Meerut Development Authority versus
আমি দেখিয়ে দিয়েছি তো
Association of Management Studies and another.
এনজি প্রজেক্টটা দেখিয়ে দিই
With Pawan Kumar Agarwal versus Meerut Development Authority and another. Reported in AIR 2009 SC 2894. Paragraph 13.
17.
17.
Para 17.
Wherein
Fair.
the court held that the terms of the invitation to tender cannot be open to judicial scrutiny because the invitation is in the realm of contract. Stop. Limited judicial review may be made in cases where it is established that the terms of the invitation to tender were so tailor-made to suit the convenience of any particular person with a view to eliminate all others from participating in the bidding process. Stop. The bidders have a right to equality and fair treatment. Stop. In the instant case, it appears that the
concession for civil class civil has been withdrawn.
the concession which the petitioner claims
In case of civil class civil tribe had been withdrawn.
in respect of reserved category candidates was absolutely in general. Stop. The same was not meant only for a particular person. Stop. Paragraph, learned advocate for IOCL submits upon instruction that several candidates of the reserved category participated in the tender process and were found successful. And offer letters were also issued in their favor. 26.
26 number of.
Achha, 26 number of candidates, SC/ST, participated, were found successful.
Yes, successful.
Successful. ঠিক আছে? In view of the above, the decision relied upon by the petitioners do not come to their aid. The petition fails and is dismissed, both together. Yes.
This matter, my lord,
14 and 22.
related to my lord, challenging a show cause notice, my lord, of willful
You
identification.
did not file your opposition?
My lord, opposition, my lord, copy has been served. Here is the, my lord, the.
Original.
My lord, may I just intervene, my lord?
No, he has not made submission. Why will you intervene?
No, because this has become infractual. My lord must be knowing.
Say it is infractious, then
Come to that, my lord.
yes.
This my lord, first writ petition was filed, my lord, challenging the willful identification committee show cause notice, my lord.
Yes.
Thereafter, my lord, the willful identification committee, my lord, had declared
Final order has passed.
Yes.
challenging that we file another writ petition.
So
my lord,
this
that is
goes.
Item 24, my lord.
All right.
22.
So this goes.
So, my lord. Thereafter, my lord, the
Thereafter will come. First, we restrict ourselves to this.
Fine.
Aljalikanen, the writ petition was filed at this stage when a show cause notice was issued by the bank as to why the petitioners will not be declared as willful defaulters. Stop. It has been submitted that during the pendency of the writ petition, final order has been passed by the identification committee, which is under challenge in a subsequent writ petition. Stop. Next. In view of the above, the present writ petition appears to have become infractuous. Stop. The same stands dismissed. The affidavit in opposition filed by the bank.
Well, that is in subsequent writ petition.
Oh, darkar nahi. Oh, yes. Next.
22,
15.
my lord. 22.
What 22?
Subsequent, my lord.
Wait, I'll go one by one. 15. Dismiss. Record your appearance, dismiss for default.
Number 59, maybe. No.
Dismissed. Union of India, record your appearance, please. Power Development Corporation.
Yes, Your Lordship. In terms of your
Order, you want to file opposition? Please.
opposition, the copy has already been served upon.
Very well. Any reply filed?
No reply filed as well.
Very well. Opposition taken on record. Next.
Well, I appear for the petitioner in this
Yes,
matter,
please.
my lord. Well, this matter is appearing after a long hiatus, my lord. The issue over here pertains to, my lord, the land being beyond, whether it's beyond the permissible limit in terms of the expression provided for by the state level impact assessment authority. Malad, the pollution control board deals with the lands wherein
Who is for your other side?
Malad, at that given point of time, Mr. Devashish Ghosh was appearing. It was a long while back, Malad, at least 3 years
For
back.
the
For Malad, the
Union
state
of India. Devashish Ghosh was for the state.
state Malad.
Union of. This is item
18 Malad.
18. Is it against the Union of India or the state?
Malad, it was against Union of India as well as state because
Union
the
of
instrumentality of the
state.
state.
All right.
So if I may, Malad, I may also serve a notice. It's appearing after a very long time, Malad.
The Learned Council is there.
She's perhaps appearing for
SPCB.
Pollution Control Board, Malad.
State has already filed the opposition affidavit. The petitioner sought time to file reply. State level environment impact assessment authority. Are you representing?
No, I'm
Okay.
not representing that.
My primary case is against the state level impact assessment authority, Malad.
Very briefly, may I submit before your lordship?
Does anything remain to be decided?
Yes, Malad. Because
is-
whether the issuance of stop work notice which had been issued by the state level impact assessment authority, Malad, forms the subject matter of the
Hmm.
dispute.
Hmm.
Because according to the petitioners, Malad, that is not permissible. It's separate independent units which have been developed. So naturally, Malad, there are separate independent developed units has got nothing to do with one another, wherein the impact assessment authority has assessed the lands as one jointly developed together. There were 3 or 4 plots of land, Malad. It's actually the difficulty is it's appearing after a very long time. It's post affidavit stage, Malad. I'm also being led by Mr. Shurojit Nath Mitro. So if the matter could appear, Malad, anytime a week hence, Malad, we can come back. It's been a long while, Malad. Sorry.
What is your submission?
I was just submitting that your lordship kindly sees that there was a direction on the State Pollution Control Board at that relevant point of time, and we disposed of the matter by passing a reasoned order. Direction for appearance, that is annexure P7.
All right.
P7 and 28/9/2022, which is annexure P8. A reasoned order was passed by the State Pollution Control Board.
Right. That is under challenge.
No, that is not under challenge. After that,
Malad,
when
there is
the matter-
another
Yes.
can which has been taken
Yes.
out for that particular purpose, which perhaps was registered as can 1.
Number of occasion the matter was heard by her lordship motion water.
Then after that, সিয়া কাছে পাঠিয়ে দেওয়া হয়েছিল।
But the writ petition was pending at that.
Is the can here? এখানে can আছে? Can নেই? Not printed above.
No, Milord.
You go for the state now?
Not for the state. Milord, they have challenged the order passed under section 5 of the Pollution Green Tribunal Act. And under section 5A, there is a appellate provision.
Appellate provision?
My lord.
They are challenging the order of the tribunal?
Yes.
No. That's not a
Tribunal,
challenge.
the
of the tribunal.
SLT also.
All right, go through it. He wants time. In the meantime, the can be brought.
Have you served copies?
Yes.
Can I have received? Can 1?
A connected application has been filed
Can you give it?
by the petitioner. Stop. Copy of the same is not available on record. Stop. Let the connected application be tagged along with the writ petition. Stop. On the prayer of the learned advocate for the petitioners to come prepared, release the matter on 11th, Monday.
Grateful.
Next.
Grateful, your lordship.
Everybody just go through the papers. It's coming after a long time. Kantaka Anaben.
I may appear on behalf of the electricity authority. Milord.
Your name?
Possible, Milord.
You say.
I'm not.
Advocate Salsuchi.
No, I'm still there.
All right, Tuesday, 12th. 12 तारीख. 12th.
My lord, I affirm of the petitioner, my lord.
Yes, please.
My lord, this pertains to the pleadings of the matters to completed, my lord. The only difficulty is having some health issues. If the matter can be adjourned for a period of 7 or 10 days, my lord, by that time I can recover and will appraise the lordship, my lord. It's in relating to non-payment of my dues for supplying of feeds for fisheries department, my lord. I have supplied food under the fisheries department under four different contracts. There are 4 different work orders. I have supplied thereafter. I demanded money. I have also made a RTI, my lord. In furtherance of that, there is no whisper that there are any kind of dispute. However, initially there is an order passed by the learned predecessor of your lordship in the single bench, sitting in the single bench, whereby 75% of the amount claimed by me was asked to be deposited. Asserting that the state went before the appellate, before the division bench, my lord. However, that order was set aside and the matter was remanded back for further hearing. Now, under that situation, my lord, the pleadings in the meantime stood completed. I also want to have the matter since there is substantial amount of more than 3 crores due is pending, my lord, as on date.
Who is
But
your
I'm
other
only
side?
my lord, my lord, Mrs. Shukla Das Chandra was appearing on earlier occasion.
Please check up. None appears on behalf of the respondents. Stop. Next. On the prayer of the learned advocate representing the petitioner, release the matter for further consideration next Monday.
Yes, ma'am.
11th.
Anytime,
Ayodhya.
lordship.
Let notice be served upon the respondents, intimating the next date of hearing.
Grateful, ma'am.
Yes, please. Who is the other side?
Mr. Pradeep Kumar Roy had appeared from behalf of the Howrah Agricultural Produce Market Committee and Mr. Ashim Ganguly for the state.
And the answering respondent will be the respondent numbers 2 to 4.
Please have a look at the order of 1st March 2023.
Not liable to pay fees under the Act of 1972. What will be the question of law that you intend to urge?
What is the effect of statutory amendment to the definition of processor vis-a-vis purchase and sale in the regulated area? Now, what the Act purports to levy is fees for the purpose of purchase and sale of agricultural produce. This agricultural produce has a reference to the schedule, to the Act. Now, not subsequent thereto, from the original statute, after the original statute was promulgated, there was an amended to certain provisions, including the definition clauses. And 2 of such definition clauses were coextensive. Now, these coextensive clauses define processing and trader. Trader is once again referable to one who purchases and sells within the regulated market area.
And processor?
So, whether
and processing?
Whether processing comes within the provisions of this Act. But we get the market produced from some other states or even from West Bengal. And they
process it over there and
it
then
is not sold. It's sent to the outlets where not the
somewhere outside the regulated market committee area, and whether it will be fees will be payable by you or not.
As market produce. So these are doughs not prepared for the purpose of manufacturing pizzas at the centers.
These are?
Pizza.
What is the material?
The doughs, flour, wheat, these are prepared in the form of doughs. These are taken in tray to those Domino's and Pizza Hut and all those outlets. There they manufacture it to a shape.
All right.
So what we do is not a product which is sold.
All right.
And these are sent to our outlets only.
That's
the question.
So they are to
probably
be heard.
there was as I'm told, probably there was a discussion with the regulated authority.
Yes.
Postage after a fortnight, we shall come back with the instruction. If it is settled out of court, it's settled. Otherwise, we agitate before this.
None appears on behalf of the Howrah Jilla Regulated Market Committee. When did the amendment take place?
But this was in 2014.
Acha. Mm. The presence of the aforesaid respondents will be required for disposal of the instant lease. Let notice be served upon the learned advocate representing the aforesaid authority, released on 18th of August. এই অর্ডারটা ফেরত দিয়ে দিন। জানাবাবু, আপনি বসে বসে ঘুমোলে হবে? Dismissed. Yes, this is the matter.
22 my lord.
Legi?
Was my lord for second part my lord. The identification committee order not be challenged in this writ petition. My lord.
Now it has gone to the review committee.
Yes.
So this has also become infractuous.
Review committee matter, my lord, that is an exhaustive writ petition that is pending. There we got stay, my lord.
Oh, then it's all right. Please come.
My lord, my
In the
position has
instant
kept-
writ petition, the petitioner challenged the order passed by the identification committee in identifying the petitioners as willful defaulters. Stop. During pendency of the writ petition, comma, order has been passed by the review committee affirming the order of the identification committee. Stop. The order of the review committee is under challenge in a separate writ petition, which is pending consideration. Stop.
WPO number 265, my lord, of 2020.
265?
WPO.
WPA
WPO, my
24
24.
of 2024.
If you are too much, I can give the order also, my lord.
WPA
WPO, my lord, WPO.
PO
WPO.
265 2024, which is pending consideration. Paragraph. As the subsequent order passed by the bank is under challenge in a different writ petition, accordingly the present writ petition appears to have become infractuous. Stop. The same stands disposed of. Affidavit in opposition by the bank filed in court today be written with the records.
Deeply obliged, my lord.
Next.
Wait, please, your lord. Pursuant to lord's direction, already have served in.
Yes.
Again to the, but a affidavit of service has not been affirmed.
Yes.
At the.
You are for whom?
Has not been disposed of.
You are there for the private respondents.
Appeal by the maintenance tribunal, appeal has not been disposed of by the DM.
When did you file?
My lord,
When did you file the appeal?
appeal, I'm coming to that, my lord.
My lord, at page 41, my lord, in this matter, I am appearing for stay, my lord.
All right.
41 page, annexure P7.
Yes.
My lord, appeal I prepared, but in spite of that, appeal has not yet been a senior citizen. Now I'm out of.
What is the reason for non-disposal of the appeal?
My lord, my specific instruction is, my lord, this appeal has not been filed, which I submitted on the earlier occasion as well.
July 2022, kindly see, received, not verified.
Right side, there is a seal, page 41. Did you verify?
My lord, I asked for the instruction on specifically on this, my lord. My lord, I am yet to receive instruction on this, my lord, though I have received specific instruction from the department that this appeal has not been filed. But if your lordship directs, then this writ petition can be treated as a representation and can be disposed of, my lord.
Sir, the act speaks of an appeal, regular appeal, and not a representation. It is there in page 41. Please check up whether the authority has accepted this and whether any number has been given. Then only next direction can be passed.
On earlier occasion, they have also pleaded this. We have not filed the earlier occasion when it was heard, and my lord was pleased to direct me to serve again copy to the private respondent. Your lord,
My lord,
same point they have taken. In spite of that, my lord, they have not taken
For last
instruction.
1 month,
From
you could
2022
not
to
get
till date.
instruction as
my
to
lord,
whether it
my
was
lord, my
accepted.
lord, when usually, since this is my specific instruction that under instruction I am submitting, my lord, that usually when appeal is filed, my lord, then an order is passed with a number generated on the appeal, and a number is provided to the appellant, my lord. But
Yes.
from the page 41, my lord, as it appears, my lord, there is no order, no number is there, though a stamp is there as received at
Maybe it has been filed in the receiving counter and then it is gone. There is no actual filing of the appeal.
and my
The
lord,
moment it is filed, a number is given. He says there is no number generated. How can you take this to be an appeal?
My lord, from
What was the order passed?
instruction, my lord,
my
order
lord,
passed.
page
Order
13
passed.
9, my lord.
Order dated
1st
My
of
lord,
June.
March
the
2022.
father-in-law is filing this appeal
June
for
2022 order dated.
eviction of the daughter-in-law, my lord.
Daughter-in-law, my lord, now from 2022 till date, my lord, I am roaming here and there. And my son and my lord daughter-in-law.
What is the son doing?
একটা দেখতে হবে তাহলে।
Will the father-in-law come under this definition?
My
My lord, the daughter-in-law does not, my lord, subject to correction, does not come under the definition of the children, my lord, or the relative.
Father-in-law and daughter-in-law, does it come? Parent means father or mother, whether biological, adoptive, or stepfather, stepmother. Where is the relative means such as a senior citizen? It's all right. Where is the provision that the father-in-law can get benefit?
My lord, mother is here, my petitioner is the father-in-law. Petitioner father-in-law, Joydev Pal.
Yes.
My lord, son Vidyut Pal.
Yes.
And Payal Pal, daughter-in-law. Respondent number 8 and 9. And
Joydev is the
father-in-law.
Father-in-law of whom?
Father-in-law of Payal and father of Vidyut.
Vidyut. So Vidyut, against Vidyut, it is all right, but what exactly do you want?
Both are torturing.
Both are son is also torturing.
Yes.
My lord, subject to correction, my lord, the petition is misleading because at page number 41, my lord, the petitioner has submitted that the son does not stay with them and stays somewhere else, my lord.
That after shifting with his wife and deserts her, the respondent daughter-in-law can easily enter in law.
The entered accommodation, the respondent daughter-in-law can easily re-enter an in-law's house and take legal recourse for the same. For that the wife should accompany her husband and live with him. For the wife does not live with her husband in amongst desertion.
Why should you be bothered about whether the husband and wife they are deserting each other or not?
Well, kindly come to page 42.
What is the 1 minute? Page 44 is the order of the subdivisional officer. Please read that. How are you aggrieved?
At them and produce document for which my lord agreed. The apparent case is that his daughter-in-law is still ill-treating him and his wife. The respondent son and daughter-in-law stay with him with his wife in house. Respondent daughter-in-law denies them access of some of the rooms of his own house, which he puts under lock. He has filed a petition in court of the magistrate being such and such. He has also filed subsequently a petition in the Honorable High Court such and such. The ill treatment suffered by him and his wife has gone to such an extent that they cannot live in peace in their own house. Hence, the applicant wants the respondent to leave his house. The respondent son admits the allegation made by the applicant and states that he works in railway and he means to rent an accommodation for himself and his wife and minor daughter. In fact, he is having rented accommodation. Therefore, he wants to leave his father's house and shift to the rented house with his wife and minor daughter. The respondent daughter-in-law denies the allegation made by the applicant above and ill treatment meted out. On the contrary, she has been subjected to abuse by her parents-in-law. She stated on demands for dowry. She further states that her husband is with her parents-in-law and the applicant, along with respondent number 1, actually trying to throw her out of their house in the gap maintenance of the parent. She further adds that she has filed a case under the Protection of Women Domestic Violence Act running in the court of the Judicial Magistrate, 5th Court, Hubli, Sachin. Having party, the tribunal of the opinion that it is a dispute between the applicant father-in-law and respondent daughter-in-law. The son has only been made a permanent respondent. The son seems to be a tactical. This portion, my lord, this portion agreed. Where from he got it without taking any evidence? I'm asking a question myself, my lord. Do not take me. The son seems to supporting the applicant father against the respondent number 2. There has been many reasons on court that the daughter-in-law has no right to live in the house of the father-in-law. However, the fact that the domestic violence is running is a suspicion that this case has been filed by the applicant convinced with his son for the sole purpose of evicting the respondent daughter-in-law from.
Who are you appearing for?
I am for the private respondent Payal Ghoshal, my lord.
Yes.
But I have not received any copy. I have received notice, but I have not received any
Long
copy
back,
of the writ petition.
long back I have served. They have
Long back,
received
my
it.
lord,
Item delivered.
Tell me one thing. What does your husband do?
Husband is an employee of railway.
Right.
Lord,
You stay with your husband?
yes, my lord.
Where do you stay?
In his father's house.
Where does the son work? Where does the son work? Where is he posted? Where is he posted?
I cannot say.
You cannot say.
Employee of railway.
Employee of the railway. The relationship between the son and the father?
Normal.
And the daughter-in-law is not normal.
Actually,
why are you not representing the son and only the daughter-in-law?
I am representing your daughter-in-law.
Why not
Son
the
is
son?
not interested, my lord, because he has been made party for show.
For show?
Oh, yes, my lord.
What do you mean to say show?
There is no grievance against him. Only grievance against me. Through him, the father-in-law is trying to evict me from the house. This is his tactic.
Your relationship with your husband is all right?
Yes, normal. She is living with me.
She is living with
He
you?
is living with me.
So it has to be taken
We
that
have
the
a
son,
child.
the son is using your wife, your husband is using you.
Husband is not using. Father-in-law is using his son to take revenge against me.
But then the son is there with you. The son will oppose the stand of the father in that case.
He is tacitly supporting father.
What does this mean?
Yes, my lord. My lord, he is not. I am. We had love marriage, my lord. From very beginning of the marriage, father-in-law has objection, and I am that is target. I am being targeted. That is.
I still cannot understand. If your husband is with you,
Yes,
then your husband has to support you.
Husband not supporting me.
Why?
Not supporting father. He has not. He
The
is not saying
husband,
anything to me.
your husband is bound to maintain the father, his father. Is the husband, are you getting any maintenance from the son?
No.
What does your son do?
Son
So
is
railway
a
employee.
railway employee.
Railway employee. And what do you do?
I'm a day labor.
You are a
day labor.
day labor.
Your 4 biggest property.
He is owner of several bigas of property.
Not several
And
biggest.
he is
4 or 3 or 4 biggest property.
So
for my instruction.
Financially very strong person.
Financially very strong.
His only intention to evict me from the house.
How many heirs do you have? Do you have your wife?
Only one son. My wife also with me.
Your
My
wife is there
yes.
with you. You want to evict your daughter-in-law from that place?
That is the intention.
My
What?
wife, with me.
You want to evict your daughter-in-law from that place?
Not only daughter-in-law, also son.
You want to evict your son?
Because otherwise they will separate their mess and take 2 rooms I will accept them. 2 rooms, but not to disturb every day she and my son disturbing me.
How big is the house? How big is the house?
But 2 floor.
Two-storied building, more than
2-story.
4 rooms. More than 4 rooms.
2-story building.
Two-storied building. He is the owner of two-storied building.
You don't mind if your son and daughter stays in a separate mess in the same house?
Same house.
You do not have any objection.
I take instruction from
Right.
my instruction is this: no problem. I
Yes.
will not evict him, but
They will not
take 2
disturb you.
rooms. Out of 4, they will take 2 rooms.
Please inquire whether there is a different access, separate access
Madam,
to the first and the second floor. And in case you want your son to stay over there, which portion of the house would you like to leave for them? The first or the ground floor? You also take instruction.
Every day, every moment, he is using, that is father-in-law using rough language against me. And
Listen, your husband is a railway employee.
Yes.
Stay separately from the father-in-law. Do not stay in the same
that
place.
that if my husband provides me
kindly
any
give me-
shelter, I shall go there.
kindly give me 5 minutes time. I'll do.
Not 5 minutes. Let him also take
I'll talk-
instruction.
Kindly direct him to once.
Kindly give me 5 minutes time. I'll take call Mr. Joydepal and take instruction.
Very well. Day
5
after
minutes time.
day after tomorrow. Acha, ashun to. To allow the learned advocate representing both the parties to come ready with proper instruction. Release the matter for further consideration on 6th. State Council shall also take instruction in the meantime.
My lord, on the
Appeal
this
as to
appeal,
whether
my
the appeal was filed or not. Legal. Acha. The petitioner alleges that his son and daughter-in-law, who stay in the same house, regularly tortures him and tortures him, for which the petitioner intends intends his son and daughter-in-law to move out from the said house. Stop. Paragraph. It has been submitted that the house consists of 2 floors. Stop. Parties shall revert with instruction as to whether there is provision for separate access to the floors and whether the petitioner and his son and daughter-in-law can live separately in the said house. Specific instruction. A copy of the writ petition, please.
My lord, I will come with the instruction, but still, as of date, my lord, the specific instruction is that the appeal has not been filed, my lord.
All right. Next.
Much obliged. With your kind leave, my lord.
लेकिन
Service. Yes. Dismissed. 25 dismissed. 26.
Milord, I am for the respondent number 3, Himadri Shorkar, Milord. Milord, I am praying for a not today, Milord.
Why?
Milord, I will come with instruction, Milord. I don't have the instruction right now.
Probably become infractions.
Yes.
It has become infructuous. Learned advocate for the petitioner submits that the writ petition has become infructuous due to efflux of time.
But there was an injunction restraining the district magistrate from dissolving the district sports association.
Due to subsequent developments that have
This
taken
election has been
place.
conducted and the new board has been constituted.
Very well. হয়ে গেছে? Next. 27 dismissed. What is it? 27, 28, 29. Yes. What is it?
You would see the last order.
Yes.
Respondents had seek time as they were not prepared in the matter.
Respondent Karnataka Bank.
Yes. Or in all the 3 matters. 27, 28.
Yes.
I'm being led by Mr. Shunashattu Banerjee. Lordship.
Learned counsel appearing with the respondent number 2 seeks time to get ready. What is the issue?
We have been
From proceeding with the hearing in terms of the
we are enjoying an interim order. I'll indicate the matter in short, Your Lordship.
Hmm.
The matter is.
What is the hearing about?
Yes, it's with respect to willful defaulter, Your Lordship. The
What has
notice-
happened?
So notice has been issued in to us on asking us that on certain grounds which has not been indicated properly, Your Lordship. The grounds were not indicated properly. On one particular ground that the borrower has failed to repay and that it has sufficient amounts in the account. On that basis, notice was issued. Thereafter, we filed our reply. We issued our reply. Thereafter, another notice was issued stating that personal hearing will be granted to us and the venue will be in Bengaluru. Your Lordship, the account is in Calcutta branch and they have asked us to come to Bengaluru. That is why we thereafter we prefer this instant repetition challenging both the notices. Two notices. The first says stating that we are the willful defaulters, and the second notice stating the venue to be in Bengaluru. We have challenged both the notices, and it was back then Mr. Shoshatha Banerjee had pleaded this, and an interim order was granted in our favor. So restraining the respondents from taking any action with respect to the personal hearing.
Are you still operating the bank accounts?
Yes. Yes, Your Lordship.
And as regards payment, did you make the payment?
No,
You,
Your Lordship, that's
the
the
issue
entire
was regarding
dispute.
willful defaulter. What
They have taken Surfacey action, Your Lordship.
They have taken.
Yes.
And then
It's been pending, Your Lordship, before the DRT.
none represents the Karnataka Bank. Let notice be served. Release the matter for further consideration on 18th August. Next. 27, 28 and 29 same order.
Grateful.
I pay for the respondent bank, Your Lordship.
30 petitioner is not here, dismissed.
Grateful, Your Lordship.
Record appearance of the bank.
Lordship, this is my application, item number 31.
Yes, please.
31, Your Lordship. Lordship, an interim order was passed on the last occasion, on 19th May 2023, wherein the respondent railway was restrained from acting in terms of the impugn notices, including the termination notice dated 25th February 2023, or forfeiting the security deposit or encashing the performance bank guarantee of the petitioners. Lordship, it has come to my knowledge, Your Lordship, that they have already encashed the bank guarantee, Your Lordship. Yes, Your Lordship.
When? Was it a time-bound order?
No, Your Lordship. The petitioners were directed to inform. We had informed the railways not to act.
To communicate this order on the respondent railways by the railway liberty applications are passed before the vacation measures. Any issue? Nineteenth May 23, this interim order was
Yes,
passed.
Your Lordship. And Lordship, I think they have.
And nobody appeared for the railways.
We had informed the railway, Lordship. We had intimated the order.
When?
On 23rd May 2023, Your Lordship.
All right.
This is. And on 22nd of May 2025, they have encashed this.
So they did not know about it.
They knew about it, Your Lordship, via mail and through speed post.
But then you communicated on 23rd, you say?
23rd May 2023, Your Lordship.
And this is in
25,
24?
Your Lordship.
25?
Yes, Your Lordship.
All right. What you intend to do with the writ petition?
Lordship,
Do you intend to proceed?
We'll proceed, Your Lordship.
Because after the bank guarantee has been encashed, the writ petition appears to have become infructuous.
My Lord, will kindly keep it for the time being, Your Lordship. I'll come back with the writ petition, Your Lordship. In the meantime, if I may, I'll file a contempt against the railways, Your Lordship, if directed. My Lord will not dispose it of, please.
Please come. None appears on behalf of the respondents. Learned advocate representing the petitioners submit that despite having knowledge of the order passed by the court on 19th May 2023, the railways have proceeded to encash the bank performance bank guarantee. Stop. Leave granted to the petitioners to file supplementary affidavit disclosing facts which arose subsequent to the filing of the writ petition. Stop. Such supplementary affidavit may be prepared and circulated by 12th August. Release the matter on 26th August 2025.
Great, Lord.
My lord, I am for the petitioner. I am praying for the grant of time to file affidavit in opposition, my lord.
You are for the petitioner?
Yes, my lord.
You want to file opposition?
Lordship, 1 second. Who are you appearing for?
Item
Item 32. Who is it?
Mr. Anik.
32? What is the who is your client? What is the name of your client?
Sanjay Kumar Bhagat versus Union of India.
Yes.
Are you appearing for Sanjay Bhagat versus Union of India?
Who has instructed you to seek time?
My lord, Mr. Anik Pandit.
Mr.
Anik Pandit.
Who is he appearing for?
In this matter, for the petitioner, it's Mr. Shobhi Kundu who is appearing on.
Yes, my lord. I can see the advocate is there.
I think you are.
Yes, my lord. I think there's some confusion, my lord.
Right.
Apologies, my lord.
Lordship, I am appearing for the petitioner in this matter. Mr. Rudaman Bhattacharya is leading me. He is presently traveling, Lordship. If the matter can be kept any day next week, Lordship.
Traveling is not a ground for seeking adjournment.
Lordship, also, I agree, Lordship. It's for final hearing, Lordship. On the last occasion, directions for filing notes were passed, Lordship.
Who is for the respondents?
My lord, I am appearing for respondent number 3 and respondent number 4.
3 and 4.
Yes.
And for ROC, Lordship, Mr. Pramit Roy was appearing back
yes,
when the matter was taken up about
Right.
2 years ago, Lordship.
Accommodation has been sought for by the learned. Now, on behalf of the learned counsel representing the petitioner. Stop. None appears on behalf of the. Are you there for
My lord.
1 and 2?
I'm for 3 and 4, my lord.
3 and 4. None appears on behalf of the respondent numbers 1 and 2. Stop. The respondent numbers 3 and 4 are represented. Stop. The affidavits are not required. Is it a point of law?
We had a notes which are ready. It's a very short point of law. So notes
Point
are
of law.
Yes,
Yes,
the
Lord.
point of law, leadership.
Give your notes. I can keep it on record.
Lordship, I am also filing my notes, Lordship.
Please get
There? Within 3 days?
Yes, it's ready.
Leadership, it's ready, but maybe file it within 3 days. You said. Or maybe tomorrow. Can you do it tomorrow?
yes,
We can do it tomorrow.
Oh, thing is, this bench did not hear the matter. So notes of argument.
Leadership, may I suggest, may I submit this? We'll file the notes and we'll make submissions again. So that with the notes in front of your leadership will
So that you can file it when the submissions are
do that.
advanced.
We'll do that. We'll do that.
That will be better. Any interim order, any party
No,
is
Lordship. No,
enjoying,
interim
nothing
orders.
of the sort.
No, Lordship, there's no.
Very well. The matter, a point of law appears to have been urged in the instant writ petition, which is required to be decided upon hearing the parties. Stop. The parties are ready with their written notes of argument. Stop. List the matter for hearing in the combined monthly list of November 2025.
Lordship, could it be next week, Lordship?
No, hearing cannot be done. November 2025. Stop. The notes of argument can be filed immediately after oral arguments are over.
Very deeply obliged. Grateful.
Next. Dismissed. Dismissed. Thirty-four?
Yes, my lord.
Yes,
I
what
appear
is the
for
matter?
petitioner, my lord. My lord, this matter has come at my instance, my lord. May I file my affidavit in reply, my lord, to the affidavit in opposition filed by the, my lord, this pertains to, my lord, an award passed by the West Bengal Clinical Establishment Commission, my lord. My lord, the commission has awarded a sum of rupees 9 lakhs in favor of the victim's father, my lord. Now, challenging that order, my lord, I filed the writ petition, my lord.
All right.
My lord, I'm enjoying an interim stay on that order, my lord. Lord, the 9 lakhs of rupees that was passed by, my lord, the commission was stayed by a coordinate bench of
Yes.
the court, my lord. Not only one thing, my lord, in the affidavit in reply, my lord, I have inadvertently, my lord, not annexed the deposition of the victim's husband, my lord. So, my lord, I would be requiring some time, my lord, to file a supplementary affidavit because, my lord, it took me some time, my lord, to obtain the deposition from the commission, my lord, of the victim's husband. My lord, I was only praying for a week's time, my lord. I'm ready with the matter. Otherwise, I'll serve an.
Who are you representing?
I'm respondent number 2, your lordship. I am my client has suffered. He has obtained the decretal amount, but he has not yet received that amount. My daughter died for the laches of the hospital itself, and I have categorically proved before the
Commission.
tribunal. Yes, and I have not received any amount, your lordship, till date. No compensation has been received.
All right.
I filed my opposition today.
Now, if you file a supplementary, he will file.
Again, I have to use.
Again, he has to use a supplementary reply.
May I do this, my lord? My lord, I'll serve an advance copy on him, my lord, as soon as possible. Maybe, my lord, by tomorrow. Lordship keeps it on any day, my lord, because, my lord, this deposition is very important and critical to my writ petition. My lord, will have a bearing on the writ petition, my lord, because it is the deposition of the victim's husband.
My prayer is today, some amount should be released. Some amount should be released today. Not the full amount, at least a certain amount should be released in favor of the respondent number 2 here, in your lordship.
My lord, there's a stay on that order, my lord. Unless your lordship hears that, my lord, I will not be in a position, my lord, to appraise your lordship of the full and facts, my lord. My lord, any day, my lord, will give me the shortest possible day, my lord, I'll come back.
Please come. And represents the West Bengal Clinical Establishment Regulatory Commission. Stop. Learned advocate representing the petitioner submits that. No, not submits. Prays for a leave to file supplementary affidavit annexing the deposition of the
My lord, the victim's husband.
victim's husband. Stop. Affidavit in opposition and the reply. Affidavit in opposition by the respondent number 2 and the reply thereto by the petitioner are taken on record. Stop. The petitioner is already enjoying an interim order. Petitioners hobe. Enjoying an interim order. Stop. As sought for by the petitioners, comma, time to file the supplementary affidavit is allowed till 14th, exception if any by the private respondent may be filed by 29th. List the matter for hearing in the combined monthly list of November 2025.
Your lordship, notice to be given to the respondent number 1.
My lord, we'll serve.
A formal.
Yes, let notice be served upon the respondent number 1, intimating the instant order.
Your lordship, the one is there.
The Clinical Establishment Regulatory Commission.
You are there?
My lord.
তাহলে ওনার এটাকে নানা পিয়াজটা কেটে দিন, নামটা দিয়ে দেবেন।
ওরা একটা supplementary use.
পেছনে যে কমিউনিকেট করার কথা আছে ওটাও চলে যাবে।
Your lordship, one, I am opposing their interim order because that was a limited, it hasn't passed for a limited period. Your lordship.
Thereafter not extended?
Not extended.
দেখি
Only one order is there. 12th of
দেখি ফাইলটা
The interim order is. Lord, paragraph 9 of the order says, my lord, impugned order passed by the commission is state.
Until the matter is heard out further. Acha, তাহলে লিখে নিন যে the interim order which was granted on 12th May 2023 is extended till 19th December 2025 or until further order, whichever is earlier. Dismissed.
Well, I put the respondent 36.
30?
36.
All right.
The learned advocate of the petitioner is suffering with viral fever. Just requested me over telephone, please make it not this week. Only.
Lord, I appeared for the respondent numbers 9, 10, 11,
Well, I mean
13,
19.
14 in number 37.
All right.
36
And
for a 9 and
37 you are for the petitioner.
36, 9 and 10.
All right, I understand.
Two are clubbed together actually. my lord.
Yes, I see.
I appeared.
Learned advocate representing the petitioners in item 36 seeks accommodation. Stop. Next. The
My lord, in the meantime, my lord, since being adjourned, my lord, may you pray for come with an
I-
affidavit in opposition?
item numbers 36 and 37 are being heard together. Stop. Learned advocate representing the private respondents. What is the matter about?
My lord, this is they claim to be an unauthorized construction. We say no, it's not.
Unauthorized construction over government plot of land.
Yes.
Encroach, my lord.
Encroach.
Violating the West Bengal
That is the allegation.
allegation.
You are
Order has been passed, my lord.
The private respondents.
Take
This is for
position.
the official respondents. State.
My lord, I'm for the state in 36.
What is your instruction?
My lord, I'm yet to receive instructions, my lord. Within the next
From
week.
23, you are yet to receive instruction.
Well, order already.
Did you seek instruction at all? From whom?
My lord, from the BT.
Video. Land. Whose land is it?
My lord, there is an earlier order of the
My lord, kindly
bench.
57
My
order.
matter, my lord. There is an
Already order.
there's an earlier order of the coordinate bench, my lord, where my lord, they said there are let's say about 10 encroachers who are according to the petitioner, they are obstructing the ingress and egress of the petitioner's house. According to that, and there's a finding that out of that there are certain number of encroachers, alleged encroachers, my lord, who shifted their shops and establishments. So far as my clients are concerned, they said we are not encroaching. And Justice Mantha's my lord, order is there. He said that so far as the others are concerned, you move the appropriate civil forum. That is staring on the face, man. That's the
My lord,
reflex and petition.
already there already.
So that's the reason I was amply playing, my lord, since your lordship is adjourning, my lord, may we come up with an affidavit, my lord?
No, my lord. My lord, encroachment may be, my lord, page 57. Order is already there. Remove the encroachment.
The petitioner seeks accommodation.
Now, therefore, in exercise of the power,
Are being heard
one
together.
of the
এটাকে আগে করে দেবেন. Both the matters is heard together. 36 seeks accommodation. The matter relates to unauthorized encroachment over public property. Staff learned advocate representing the state respondents is directed to revert with written instruction. Released on 18th of August.
Yes.
In the meantime, if you choose, it's up to you. I'm not passing any direction.
They are encroaching government land, my lord.
Yes.
PWD.
Seek instruction from the PWD, not BDO, because he says it's
Yes.
PWD land. Followed?
Challenge order of the PWD.
I'm for the restaurant 2 and 3.
Yes. Appearance recorded, dismissed. Dismissed. Are you there? 40 dismissed.
For your ladyship, I appear for the petitioners.
Yes.
Led by Mr. Shakus, I am requesting for the shortest possible password. He's on his legs, he's coming.
All right, pass over.
Grateful.
My lord, I am for the petitioner, my lord. Petitioner wants to withdraw this writ petition, my lord, but till date, no written instruction have been received. My lord, kindly keep it tomorrow to be mentioned. I will with the instruction come.
Learned advocate for the petitioner submits that the petitioner does not intend to proceed with the writ petition any further. Stop. She is awaiting written instruction from her client. Stop. Prayer has been made to post the matter. I'll keep it on Thursday. You get more time. 7th. Under the heading to be mentioned.
I am for respondent number 11, my lord.
For respondent number 7 and 8, my lord.
Dismissed. Dismissed.
State lordship.
All right.
Respondent number 7, my lord.
7. All right. Give your appearances. Dismissed.
My lord, I appear for the respondent, my lord. My lord, I'll beseech for dismissing it on merit for the reason that when this writ was entertained, that point of time, DRT was not functional. Subsequent to which, the petitioner has approached Debts Recovery Tribunal and have filed the Section 17 application. The Surfacey application number is 186 of 2024. So, per se, today this writ anyways becomes infructuous.
All right. None for the petitioner. Stop. No accommodation sought. Learned advocate representing the bank submits upon instruction that when the writ petition was filed, the Debts Recovery Tribunal was non-functional. Stop. After the tribunal started functioning, the petitioners have approached the tribunal by filing securitization application being SA number 126 of
186 of 2024.
86 of 2024, which is pending disposal.
Yes, yes.
Stop. Next. As the petitioner remains unrepresented, the writ petition stands dismissed for default.
Lordship, item number 43, your lordship. Lordship, item number 43 matter was taken up before Honorable Justice Modhuresh Bhattacharya, Modhuresh, lordship, in courtroom number 4, item number 43, your lordship. I'm for the petitioner.
Yes, it has been dismissed.
Lordship, kindly do not, your lordship. I'm appearing for the petitioner.
Other side was there. Bring your other side. Quite a few respondents
43
have responded. So you please get hold of them.
Lordship, 43 তে কে ছিল একটু বলুন, আমি এক্ষুনি নিয়ে আসছি।
Call, check up the YouTube recordings. Do not stand on the way of these officers. They are performing court's work. 47.
My lordship, I am appearing on behalf of the petitioner. My lordship,
Yes.
on the last occasion, the Honorable High Court has been passed a direction to serve a copy of the notice to the respondent authorities.
Yes.
And the affidavit of service has been filed. My lordship, on the earlier occasion, the Honorable High Court has been heard the matter and thereafter directed to pass a direction. But despite of that, till date, the bank authorities has not submitted any report till date, your lordship.
Give me the order where the court directed.
Yes, yes.
No, give the date only. In this matter?
Yes, yes, your lordship. 19th March 2024.
I have the copy. None for the bank. Petitioner's bank account has been frozen. On the complaint has been lodged in Kerala. None represents the respondents. Stop. Let further notice be issued. Release the matter on 18th August.
Grateful, Your Lordship.
Date I'm appearing for the petitioner, madam. I'm praying for a not today, madam.
Why?
On the ground of Mr. Siddhartha Banerjee, he is in Delhi, madam.
He's in Delhi.
Delhi.
Let him stay in Delhi. Let him not practice over here. It cannot be done.
Madam, any day, madam, any day.
What any day? Today is the day.
Madam, any
What
day.
any
As
day?
my lord pleases, my lord, any days.
Who are you for?
Respondent bank, man.
Respondent bank. Learned accommodation. Learned advocate for the petitioner seeks accommodation. Released on 18th.
Grateful, madam.
Let notice be served upon the non-appearing respondents intimating the next date of hearing. Next.
Lordship, I
This
beg to
matter, I
appear
am for
virtually on
state.
behalf of respondent number 1 and 2, Lordship.
All right.
My lord, only one difficulty is there. My brief has not been failed to trace out the brief. Must kindly.
Who are you for?
I am for the petitioner.
49?
49, my lord.
Yes.
But I've missed the brief, my lord. My lord, kindly fix it any date. And in between, I'll take the I'll photostat copy from my learned friend, my lord. Any date, my lord.
Same order, accommodation sought for 18th.
Obliged, my lord.
Grateful, my lord.
Grateful, my lord.
I am appearing on behalf of the petitioner, my lord. I am being led by Mr. Uday Shankar Chattopadhyay. I am praying for not to do it. He is on links in court number 11.
Call him, I'm passing it over.
With regard to item number 43, Your Lordship, have ascertained from the YouTube, Your Lordship, they're not the
First of
state
all, let me tell you,
Lordship.
the volume in which you were speaking outside the courtroom actually disturbed the court proceeding.
Lordship, I
Please be
apologize for
careful.
that, Lordship, I
Please be
apologize.
careful. And now the list is going on. Do not disturb in the midst of the list. When I rise, you please mention.
Lordship.
50. Dismissed.
Lordship, in this matter, I am instructed to appear. It's a change brief, Your Lordship. Today itself only I have got the.
Today is the first day after the change.
Yes, Your Lordship. Now, Your Lordship, the difficulty is, as per my instruction, the affidavit of service would not be obtained. So my humble prayer before you.
What is the matter? You've gone through the brief?
No, just today I have not gone through the brief as of yet. But Your Lordship, I think it is against the order of the insurance ombudsman.
Insurance ombudsman.
Your Lordship.
Yes. Achha, accommodation sought for 18th. Serve all the respondents.
Grateful.
52 টা আলাদা একসাথে কেন
Against the same parties, petitioner is the same. On record is also the same.
But
What is it?
52 minute, I am for the respondent. They have filed an application under the Right to Information Act. Information not provided. Your Lordship knows there is a provision of appeal. But they want from a consideration of that representation. But if Your Lordship knows, if the reply has not been given, there is a provision of appeal. And
What is the next matter?
Next matter, I don't know. In the first matter only, WPA 23355, I am appearing for the state.
You are appearing?
Yes.
With him. Achha, dismiss for default record appearance of the councils for the state.
52.
53, 54 একসাথে তো 52, 53.
54 in its
Yes,
matter, I am appearing for the state, my lord.
Yes.
The petitioner before Your Lordship purchased one land from the respondent number 7 and 8 in the year 2010. Now, my lord, in the year 2010, respondent number 7 and 8, which was, my lord, he sold out one plot to the, my lord, the respondent number 9.
Now I have purchased the land of the respondent number 92. So, my lord, I have purchased two plots, one from 7 and 8, who is the original owner, and my lord, one plot, my lord, the adjacent plot from respondent number 9, who also, my lord, which was sold by 7 and 8.
Hmm.
Now, my lord, 7 and 8, out of that, my lord, one piece of land, he mortgaged before, my lord, I purchased this as a bona fide purchaser. My lord, it was not in my knowledge, which was, my lord, sold out to 9, 9 sold out to me.
Hmm.
Now, my lord, a Surfacey proceeding has been started. Now, my lord, I have filed a civil suit. My lord, where, my lord, I have got an order of injunction. My lord, kindly come to page 43 for once.
What is your prayer over here?
My lord, the ultimately, my lord, there is an injunction, my lord, because the plot is Schedule A and Schedule B. Schedule B is mortgaged by him. Now, my lord, my house is at Schedule A. My lord, there is a order of injunction in the Schedule A of the property. Now, my lord, the section 14, my lord, proceeding has been started in the Surfacey. My lord, all I am saying is that, my lord, I am not the borrower. My lord, I am not the person against whom, my lord, the proceeding is to be started. My lord, the borrower is the respondent number 7 and 8. Malad, all I am saying is that they let them try to find out 7 and 8 and Malad, the proceedings to be drawn against them. Now, Malad, I am a bona fide purchaser. Now, Malad, they are trying to liquidate my property.
You cannot be helped. Surfacey proceeding, you go before the tribunal. How can a civil court enter into a matter where there is a mortgage?
Affirmation of the civil court.
I will not look at it any.
Malad, the
Nothing.
civil court says
One
the
report has
mortgage
come from
property
the
is
concerned police station, my lord.
Police station?
My lord.
Not from the DM?
No, my lord. Not
Why?
from DM,
Why you
police
obtain instruction from the police? The Surfacey proceeding is going on, you go to the police and not to the proper authority.
My lord, 2020.
Nothing doing. Please come.
If it is
Malad,
required, then I
see the order for once.
Nothing.
Malad,
The
all I'm
petitioner
saying
is aggrieved by the steps
mortgage
taken by the bank.
Malad, the mortgage property is a different property. Malad, that
By
is
the
why
bank.
we got the
To recover the loan amount, invoking provisions of the Surfacey Act. Stop. According to the petitioners, the subject property is not mortgaged to the bank. Stop. Paragraph. The bank is not represented. Stop. As the now, the bank would be obliged to take proceedings to take steps for recovery of the loan amount strictly in accordance with the provisions of the Surfacey Act. Stop. The bank shall restrict the Surfacey proceeding to the property which is actually mortgaged to the bank. Stop. It will be open for the petitioners to approach the Debts Recovery Tribunal for relief under the Act in accordance with law, if so advised. Disposed.
Duly.
Before your ladyship takes up on 55,
Not in the midst of the list.
I'll wait, madam. I will wait.
Dismissed. Dismissed. 57 dismissed.
57, I'm for the respondent.
Give your appearance, please.
I'm for the state, my lord.
Yes, appearance dismissed.
Lord, I am appeared on behalf of the National Highways Authority.
Give your appearance. Dismissed. Dismissed. Dismissed.
No, I'm the statement.
Give your appearance. Dismissed. 63 dismissed.
63, I'm waiting for the respondent, my lord.
Give your appearance. State. Very well. Appearance. 64 dismissed.
I'm for the state, my lord.
Appearance. Dismissed.
I'm for Union of India.
Appearance. Dismissed.
এই যে কাগজ রয়েছে তো।
Not I am for the respondent number 20.
Appearance. Dismissed. Dismissed.
69.
Dismissed.
70.
Dismissed.
71.
Dismissed.
72.
Dismissed.
73.
Dismissed.
Union of India.
74.
Dismissed. 74 has applications. Dismiss them also.
Okay.
75.
Dismissed.
73.
Dismissed. For the state, give your appearance.
Two, my lord.
My lord, 77, 78, 79, my lord, I am appearing for the petitioner.
Yes,
Both of the similar matter, my lord, regarding the recovery of the contractual payment, my lord. Contractor's payment from Bhatpara municipality.
All right.
My lord, the necessary party, I think, Bhatpara municipality. May I place the place before your lordship now, or my lord may kindly, as your lordship may fix a date, my lord.
Who is
As your-
appearing for the municipality? Bhatpara municipality. Who is appearing?
Well, earlier, Mr. Rajiv Kumar Mukherjee used to appear in this matter in regards to
Yes.
Bhatpara municipality.
Give one notice and come back. All right.
My lord, kindly fix a date, my lord.
Fix it on Friday.
My lord, don't give it Friday, my lord, because I have some personal problem.
These matters, payment of dues, I fix it on Fridays. All payment of due matters, right? So you can join online, let it appear in the list, and in case any accommodation is sought, it will be adjourned.
My lord, and another, may
79.
I place another one matter, my lord, where Justice Nizamuddin has was pleased to pass an order to give opposition by the municipality. The matter is not appearing. All of the similar matters, my lord. Can we?
None appears on behalf of Bhatpara municipality. Stop. The petitioner seeks payment of the dues. Stop. List the matter on 8th August. Under the heading payment of dues, stop, let notice be served upon the learned advocate representing the municipality. Yes. Pradeep, municipality / learned advocate representing the municipality. In case the learned advocate is not there, then at least the municipality should be served.
With respect to item number 70, your lordship, we were just on the stairs, we just missed it.
Give your appearance. Give appearance.
70.
Has passed over item number 41.
Please wait.
78.
Same order, 78 and 79. 78.
For the state, your lordship.
Give your appearance. Yes.
Number 18.
Dismissed.
81.
Dismissed.
82.
Dismissed.
83.
Dismissed.
84.
Dismissed. All right, give your appearance.
85.
Dismissed. Dismissed. Appearance. Yes, dismissed. Dismissed. Dismissed.
90, Your Lordship, I am for the petition.
Yes, what is the matter? What is the matter?
This matter relates to, Your Lordship, my land has been declared under the Enemy Property Act, Your Lordship.
Yes.
Now that land on whose name that certificate was issued, Your Lordship, that land does not belongs to him. It belongs to his brother from whom I have my father purchased. Thereafter, it was transferred to in my name, Your Lordship. If Your Lordship kindly comes to page 51, Your Lordship.
Yes.
The second paragraph, Your Lordship. And whereas the immovable property measuring an area of 10.34 acres situated at Mauja, jail number such and such, PS such and such district belongs to or is held by Khan Sahib Riyazuddin Ali, Your Lordship. Now he became resident of Pakistan, citizen of Pakistan, Your Lordship. If Your Lordship kindly comes to page
What is the date of page 51?
that is the certificate, Your Lordship.
Yes, what is the date? 26th
That
October
is 20th October 2016.
16.
Thereafter, in 2023, Your Lordship, BLRO gave me a show cause that you there is a, if Your Lordship kindly comes to, that is under challenge, Your Lordship.
BLRO's notice.
My Lord. Thereafter, Your Lordship,
Where is the
learned that-
notice? Where is
My-
the notice?
That is at page, Your Lordship, 46. Now, after getting this notice, Your Lordship, thereafter I have learned that this property has been declared as enemy property and a certificate has been issued in 2016. I made an RTI, Your Lordship. Thereafter, I received those certificates.
What exactly is the challenge?
Well, this notice as well as the certification, Your Lord, the certificate.
Certificate is page 51.
My Lord.
And the notice of the BLRO?
46, page 46.
46.
Many land has been declared as any property here.
Yes.
Under the one of my land is DAG number 6847.
See, 51A under the WBLR Act.
My Lord.
If you are aggrieved, you have to go before the tribunal. How is the writ petition maintainable?
Madam, I am not on that. Your Lordship, enemy property act, also there is no tribunal for that. Your Lordship.
No, regarding the Land Reforms Act.
Madam, this is a notice where accusation has been taken on the basis of the certification issued under the Enemy Property Act. That is the reason, Your Lordship, I have challenged this under writ petition.
Are you aware who's appearing for the state?
No, Your Lordship.
Did you serve the
The
GP's
Union of
office?
India is the party, Your Lordship, that I have served.
The BLRO will be represented by the state. Please come. None represents the respondents.
Even state has been also served.
Let further notice be issued. Released on 18th of August.
Right.
Inquire from the GP's office who's appearing for the state respondents and the enemy properties serve the Union of India.
He has been. I'll serve notice again.
Yes, 11 Strand Road.
My affidavit of service to be kept.
Service is taken on record.
My lady.
Your Lordship, I am for the petition. I am praying for kindly. I am praying for not to take this matter today, Your Lordship.
Why?
My senior is absent. He is traveling from Murshidabad. So
traveling is not a ground for adjournment, right? Accommodation sought for on behalf of the petitioner. 18th. Let notice be served upon the respondents communicating the next date of hearing.
I'm appearing on behalf of respondent bank lordship.
All right, record your appearance. Dismissed. Dismissed.
94.
Dismissed.
95.
Dismissed.
93.
Dismissed.
My lord, 96, my lord, I appear for the respondent number 8 to 11, my lord.
All right, your appearance will be recorded.
Grateful, my lord.
Dismissed. Along with the application. 98. Dismissed. 99. Dismiss. 100. Dismissed. Call the passover matter. Item now 41 passover matter.
I am appealing for the petitioner, my
I'm
lord.
appealing on behalf of respondent number 1.
Well, here, my lord, principal grievance is, my lord, proceeding before the MSME council is not proceeding. On the ground that they say they are relying upon they means, my lord, my other side is relying upon a so-called award passed in a earlier matter, which I say is a nullity, cannot be taken considered by the court. It's a case of unilateral appointment of an arbitrator of their own general manager, and because of the amendment after the 2015 Amendment Act, all cases of unilateral appointment have been declared bad. So, my lord, I made a fresh reference to the council because I am an MSME. On that basis, my lord, conciliation proceedings were held. Conciliation proceeding terminated. Then arbitration was started. And thereafter, after the first meeting, my lord, it stopped because they have referred to an award. But this council is in scene of the matter. They must pass an order, pronounce good or bad that my claim cannot be considered because it is already adjudicated, whether it is a nullity or not, that has to be decided by the council. Council cannot say that I can see one award, therefore I will not pass. They are not terminating the proceedings also. It is only 1 minute, so I have annexed the minutes, and my specific case is that after that meeting, there has been no further notice of the proceedings.
Page 170.
Show me that they entered
Yes, my lord, page
into a
176.
proceeding. 176.
Good or bad, my lord, whatever reason they give. Kindly see, my lord, regarding the above referred matter, arbitration process that was convened by Micro Small Facilitation Council as per section 18.3 of chapter 5, wherein both the parties are requested to attend the arbitration through online hearing on such and such to answer all material questions. As per power conferred under section 18.4, council is conducting arbitration in dispute between supplier located within its jurisdiction, buyer located anywhere in India. Name of the arbitrator such and such, along with members of the council. Point of contention, delay in payment against supply filed by Naveen Tools, my client, against general manager, small arms factory. The council will hold online arbitration hearing through WebEx. You are advised to join the said hearing through shared link such and such. So this is the only minutes which we have received, and thereafter your lordship will see my pleading is there in page 7.
Did the hearing take place on this 20th of July 23? Online hearing 20th of July is the date fixed?
There is no further minutes which have been given to us.
Did you join?
Yes, yes, we have joined. We have joined.
All right. What is the reason?
Lordship, two things. Lordship, if kindly comes to page number 4 once. Page number 4 of the writ petition, Lordship.
Yes.
Clause, point number H. Lordship,
Yes.
H. The late date of invocation of the arbitration clause is 21st April 2024.
2014.
2014, pardon me, Lordship. In regard to the arbitration clause, arbitration act, amended act, the section which my learned senior friend is referring comes under 7th schedule. It was introduced in 2015, Lordship. After the arbitration clause has been, this arbitration letter of invocation has been given. So this schedule is not applicable on them. Schedule 7 is not applicable to them.
On the merit.
Second thing is that, Lordship.
But why doesn't the council pass an order?
Lordship, the award has been passed.
After this,
not the council, the arbitrator, what has been passed.
let the council say that there is a award of the arbitrator and we will drop the proceeding. Why is the council sitting over this?
Lordship, then I'll come back with the instruction because according to me, Lordship, according to my understanding, Lordship, they have participated and they have filed their SOC also.
Where?
Yes, they have filed their SOC.
No, where, in which proceeding?
This
Page
proceedings only
176?
before this arbitrator only.
Before the council?
Before the arbitrator. They have filed their SOC. And now they are taking the point
Please
that
come. Pradeep. The petitioner is aggrieved by non-disposal of the reference by the West Bengal Micro Small Enterprises Facilitation Council. Stop. It appears that by communication dated 12th July 2023, the chairman of the council requested the parties to attend the arbitration process through online hearing on 20th July 23. Stop. Grievance is that since thereafter, the matter has not been disposed of till date. Stop. Learned advocate representing the official respondent is directed to revert with written instruction. Released on 18th. Stop. Let notice be served upon the non-appearing respondents,
Lordship kindly keeps it on
intimating the
19th.
next date of hearing.
On 19th, Lordship.
Make it on 19th. All right. Affidavit of service. Who has not received it?
The third respondent, my lord.
Has not received?
No.
The notice or the writ petition?
The petition was received by him, but the
Respondent number 2 and 3 have not received.
The writ petition.
Sorry, 3.
3. Writ petition not received.
writ petition received.
The notice.
No,
This
writ petition has been
application has
received,
not
the
been served.
application has not been received.
This
What is the
application
application
is
for?
Application, my lord, is a urgency application, my lord.
Doesn't matter.
Yes.
Application stands disposed of.
Huh.
As the writ petition has been taken up for consideration. Yes. Next passover matter.
Forty-three.
43.
43, I am for the
Petitioner.
petition, but Rashmi Ghosh is appearing for the petition. I am leading her. But it was dismissed for default. Kindly recall the order, my lord. Kindly,
Place it. I am passing it over. Place it.
kindly recall the order. I am
Recalled. Place it.
no brief just now.
What is this? You are without a brief.
Make it not today because my lord, your lordship was pleased to give direction to her to mention the matter on 4:30. He just tell me that. Kindly
Accommodation has been sought for. Released on 18th. Let notice be served upon all the respondents communicating the next date of hearing. Next.
18th.
Yes.
Obligation. Good.
No passover. Somebody was mentioning something. Yes.
Lordship, item 45. I stand for the petition. I was running from the Centenary building.
Yes.
By the time I come,
Was anybody appearing for the
I do not know,
respondent?
madam. Advocate on record intends to inquire, but he could not get.
Yes.
Appear
See,
করেছিল?
YouTube video recordings. You were sitting over here. You could have seen whether somebody has entered appearance.
I was sitting here, but I could not open the.
You could have gone outside and seen, or somebody could have helped you.
কেউ appear করেছিল 45 এ?
It's not possible for them to say. Absolutely impossible. The officer has gone. How will they say? 45.
45, my lord.
Please check. Recall. 45. Please.
Some
recall.
urgency, my lord.
Item number 60, my lord.
You were for the petitioner.
For the petitioner.
Yes, please.
Item number 60, when the matter was called for, I was in court number 28, my lord.
You were for whom?
For petitioner, my lord.
Item?
60, my lord.
Who was your other side?
I don't know, my lord. This matter I laid by Mr. Surfacey Chatterjee, my lord.
Whoever is leading you, did you check up who the respondent is? Any appearance given or not? Please
45
be
patient.
60.
Item number 80.
60, my lord.
60.
Your Lordship, item number 89, I am appearing on behalf of the petitioner, Your Lordship. I am coming from court room number 4, Your Lordship.
It has been dismissed. 89.
89.
89 has been passed over.
Lordship, item 64. I was on my legs in
Yeah, dismissed. Recall.
Lordship, item number 64. I was on my legs in courtroom number 2.
For whom?
I'm for the petitioner, Your Lordship.
Recall.
64.
7 and 63, Lordship has called on.
Deeply obliged, ma'am.
Till 100 it has been called on.
Your Lordship.
Yes.
Your Lordship, in the morning, Lordship, I have
My
appeared.
45 is
Lordship, in the morning, I have appeared virtually.
Recalled.
I have appeared virtually. I don't know whether it is a technical problem or not, Lordship. It has several times.
By technical problem, I saw you. I replied to your submission.
Lordship, I have stated.
You
Lordship,
wanted the matter to be posted for hearing, which the court has refused.
No, Lordship. I have stated, Lordship. After that, just it has at least listed in the monthly list, Lordship. I have tried,
Your
Lordship, since
prayer
April, Lordship.
is refused. Why don't you check some other bench taking up the matter?
No, Lordship. Lordship,
Please try. This bench is.
Lordship, granted
it's not-
liberty, Lordship. It's a mention.
one more,
Lordship,
one more 40